had fixed the matter on 22nd for undertaking motion. It is not appearing. I'm only giving.
My lord, last month, my lord, I have filed one matter, my lord, mentioning today's date in the presentation form, my lord. The matter
দেখুন আজকের date দিয়ে maybe because yesterday there was some problem, so it might not have been listed today. It will be listed tomorrow.
On 8th of April, my lord, mentioning today's date, my lord. Still it is not reaching.
Yesterday, when did you mention a matter?
One of the allow me to appoint you my advocate. That is why I filed an application for section 24 application. That is another way that matter of the reference to the lordship. Unless this matter are taken up together.
বললাম তো দিদি যে এটা অ্যাসাইন্ড হয়েছে কিনা দেখুন একবার, আপনি আমায় কথাই বললেন না। কি বলছেন হয়েছে দেখেন।
Second matter has been
প্লিজ ওয়েট।
My lord, may I be permitted to mention this matter appearing as item number 855?
For what? Upgradation?
It is already disposed of on 6th of March. It is still appearing in the list. I have not been able to get the certified copy also, my lord.
কেন লিস্টে appear
My lord, this is the order, my lord. I have already annexed the order.
ভুলভাল ম্যাটার appear কেন মেনশন হচ্ছে সকালবেলায়?
6th of March already মামলা কিন্তু
for upgradation matter. Please give your slips. Give your slip for upgradation.
upgradation on both sides. Earlier determined. This is the assignment. I am the auction purchaser. But I have spent
On Friday, this Friday auction, the assigned matters will appear.
kindly include these matters.
Assigned matters will appear on Friday. Please give it. It will appear.
Well, I am mentioning two urgent, but this is an extreme urgent one, my lord.
Write your grounds.
No, I am giving this leave. I have given the.
Write your grounds there. Don't make oral.
I have given this leave, but that nothing is being happened. Nothing is being happened.
Because I have not satisfied. Even if you orally mention, if I am not satisfied, it will not.
No, I have given this written slip.
Whatever it is in the slip, if the grounds are not satisfactory, I am not going to upgrade.
The execution came in 1989.
So
now Supreme Court has said within 6 months the execution is completed. Now we are in.
What has happened? What have you written in the mentioning?
But I have stated.
That
in 1980.
It is an application for expeditious disposal.
No,
then
this is two minutes. Kindly.
That is what you write it in the grounds of urgency properly.
I have given the
no, the grounds of urgency are not proper. That is why I have not been able to upgrade it. Please write it clearly so that I can also comprehend.
That's what earlier when
you at the time of mentioning you want the court to take a hearing, then at the time of hearing I will take another hearing. Please do that exercise, write it properly so that I can understand. Whatever you want to say, please say it in the mentioning slip.
I'll remind you. No, I am giving that. I mentioned I giving it.
Lordship, the urgency is my application for recalling of witness that has been rejected. My lord, the 11th day of this month has been fixed for argument. Special chance, last chance already given. No more chance I shall get, Lordship.
11th May, there is time. I have got your mentioning slip. I have seen it. Please don't mention the same thing again and again. Please don't do that.
I'm handing over this.
May I be permitted to leave to file this application and move it? It is urgent because 11th is the date fixed in a suit for partition. Without, I am a.
What do you want?
Urgent hearing, my lord.
Urgent hearing means?
11th is the date fixed, my lord.
So?
Otherwise, defendant number.
What do you want now? I cannot hear it unlisted. You file it, it will appear. Give whatever date you want to give, you give and file it.
My lord.
Lordship, I beg to mention item number 101 of today's your lordship's list, my lord. Tomorrow matter fixed for argument. I am the defendant. I sought for a prayer for adjournment, my lord, to place some documents on record.
01 টা call করে দেবেন. There is a caveat or no?
No caveat, my lord.
Very well.
My lord,
01 টা mark করে রাখবেন. Come at
2 p.m. my lord. I'm grateful.
I appear for the opposite party, my lord.
I appear for the petitioners, my lord.
I am for the petitioner.
Mr. led by Mr. Chaudhary.
Just for fixing a date. Because it was heard.
Yes, we have completed our submissions. Mr. S.N. Mukherjee had argued.
You give me a date on which it
My lord, may I tell you, lordship, one thing? But I live in another city. I came here for certain other matters, my lord. So I have been approached last evening, and my learned advocate on record possibly has not filed his vakalatnama as yet, because.
But he has in fact filed his wakalatnama in respect of another matter pertaining to the same party.
Oh,
And he was present on the day when this was
on 30th, if you see the order dated 30th April, I stand corrected, Willard. I was not.
Lord, may I just say something? If your
No, may I, if you don't mind, may I allow, may I make submissions before my lord, if you don't mind? Now, my lord,
Just handing over the copy of the order.
yes.
are you appearing, sir, in this matter?
Yes, I am
So
appearing
your
for the
lordship senior is also.
I'm just handing over the copy of the order. There is no
So
problem.
kindly
there.
allow me to, make
Because an
submissions.
incorrect submission was
Very
made,
well.
so I just handed over.
My seat, my lord, let them finish and whatever they want to say, then
It's
kindly
an
allow me.
extension for fixing a date. Please
Now, my
let
lord,
us-
what has happened in this matter, my lord, as I find, that this is a mountain load of files, briefs. This is just one matter. There are 4 other matters. One,
Other matters are only against extension.
Extension.
This is only
Right.
one matter which was heard. The other will be governed by whatever order is passed here. If
will
the main
abide by
order
this
was- yes,
result of this
because
matter.
This matter is the main matter.
Main.
The other matters are against extensions of this order.
Okay, very well.
So therefore, it's only one matter which you have to prepare.
Very well. So, my lord, as I have seen, my lord, as I went through this file, my lord, just a cursory glance, my lord, this is possibly a matter subject to correction where the other side has not filed written statement. Other side has not used any plaint before the trial, any pleading before the trial court. So, my lord, for the first time, before your lordships against the orders passed in Miss Appeal, my lord, the other side has come. We could not have any opportunity to deal with on oath any of the documents, any of the averments made by them. So kindly allow us to file an affidavit in opposition, because this is.
In civil revisional applications against
May
orders
I-
passed by the trial court, hardly there is any
May
scope
I,
for.
I am grateful that
opposition because that is
I am
only
grateful.
going to,
I'm grateful that it has fallen from your lordship.
Because on the last occasion also when this matter was heard, this was never the prayer.
Well, I do not know, because things have come on change. But the briefs have come on change. Now, this is kindly appreciate, my lord. This is a matter, my lord, which is not a routine civil revision like, my lord.
No, it's
Civil revision, that's right.
from a suit itself.
Civil
yes,
revision,
civil
that's right.
revision.
But, my lord, normally, as your lordship knows much better than me, my lord, this is not a matter, my lord, arising out of Order 1, Rule 10(2), or Order 39, Rule 7, or Order 6, Rule 17.
Ex parte ad interim order of injunction, against that an appeal.
That's right.
In the appeal, order refused. Therefore,
So, therefore, my lord,
simple as that. only.
that's right. So, my lord, it is a mixed question of fact and law, as your lordship knows, because the matter is coming up from an order which has been passed, rightly or wrongly, in exercise of miscellaneous appeal jurisdiction under Order 43. Now, my lord, will kindly, my lord, so this is a matter in which we could not have any opportunity to traverse any of the allegations, any of the documents that they could have possibly used before the trial court or before the appellate court. For the first time ever, documents have been filed, pleadings have been made before your lordships. So, my lord, it is not a routine civil revision matters in that sense subject to correction.
I'll only be hearing on the basis of the documents, whatever are there before the courts. It is not the pleadings in the revisional applications that I'm
There
going
was
to
no
apply.
document filed by them in the trial court.
You have filed the documents.
I have filed, but they have not.
On the basis of those documents only, I'll be hearing it.
Oh,
because
then-
that is what the
only
scope of
then, if my lord, if that is so, my lord, that if the annexures, if the documents annexed by them will not be seen
by you in the suit.
Very good.
Forming part of the plaint. Apart from that, if there is any document on which you against which you want to raise any objection, yes.
No. If that is so, my lord, that my lord's scrutiny, judicial scrutiny, will be limited to my documents only and the case. And if their documents are not seen, my lord, are ignored, I have nothing to say.
Yes, Mr. Chaudhary, are you relying on any such document which does not form part of the trial court records or the misappellate court records?
All their annexures are out.
No, my lord. My lord, we will rely on the annexures to the plaint. The question is whether, my lord, any interim order could have been granted on the basis of material brought
Mr.
by
Chaudhary,
the plaintiff to court.
Mr. Chaudhary,
Yes.
Let us make it short. Are you relying on any
Yes.
document apart from what has been annexed to the plaint or which forms part of
No.
the trial court records? Apart from that, are you relying
No.
on any document?
My lord, may kindly record that, sir.
No.
My lord, may
No.
kindly record that submission so that my
But
lord,
there is nothing to.
my lord,
there
may
is
kindly,
no
I am
question.
grateful. I am grateful that my lord,
That's the law, my lord.
my lord, may kindly record that.
And
Yes.
in your revisional application, you are, you have not annexed any document which is other than that which forms.
My lord,
My lord, maybe,
we have
my
only.
lord, maybe one or two, maybe one or two letters, my lord,
So,
may be
if
there, but
those letters are
we
relied on,
ignore
then
them. We
if
just
those-
proceed on the basis of the agreements.
if those letters are relied on, Mr. Chaudhary, then
My
in
lord,
that
we will only rely upon the annexures to the plain.
But if extensive arguments, I do not know.
My lord, we will only rely on what is there in the plain.
My lord will kindly, my lord, record that submission of the learned counsel for the other side. And my lord, if
Yes, yes.
and
Yes,
my lord,
yes.
if but yes, fine. But if my lords have already, my lord has already heard extensive arguments as have been instructed, my lord, by the other side. Now, my lord, if those arguments, my lord, have gone beyond the records of the before the trial court or before the first miscellaneous appeal, then my lord may kindly ignore those documents. I have nothing to say.
No, my lord.
I have absolutely nothing to say. Only the fact remains that the statements, that the averments made by them on oath before your lordship, because they have not said anything before the trial court or the first.
Because you are enjoying an interim order, please proceed.
Was an ex parte interim order.
That obviously, for whatever is, but they could have. What is a? I think there is a provision in the Code of Civil Procedure, Order 39, Rule 4. Please don't gesticulate and please don't whisper. If you want to say anything against me, please speak
of course,
loudly.
No, no, please don't address my.
Please speak loudly if you want to say anything against me.
He is not saying.
I'll say to the court, not to you.
Now,
don't argue amongst yourselves.
what is this?
Please
Now,
address the court.
Now, my lord, so I was telling your lordship, my lord, that the allegations that they have made here, my lord, those are telling allegations against me. That they are entitled to make and they have made, my lord. Kindly allow me, my lord, some time to deal with them, my lord. Those allegations that they have, the other side has made, allegations and averments on affidavit. This is 227, and this is a peculiar situation.
No, absolutely not. This is unheard of.
May I let them show one provision from the appellate side rules? One provision. I shall be out of the court.
Appreciate
that one
No,
provision.
no, I'm sorry.
One
We have
provision from the
completed our
appellate side
arguments.
rules.
Please
I
make
shall
your
be out of the
submissions.
court. I shall be out of
Very
the
well.
court.
Then
That a
let
party,
us do, Mr. Chaudhary.
that a party litigant.
Yes.
Please wait. Mr. Chaudhary, come tomorrow. Let us have a prima facie view of the matter tomorrow in presence of both the sides. Both of you, please make your submissions on
The day after tomorrow, my lord. I will be there for. My lord, day after tomorrow.
Very well. If that pleases them, my lord, I will be present. My lord, I am duty bound to be
just
present.
debate on this at least, whether pleadings should
But
be.
my lord, it will
exchanged
be
here
it will be human. Please, sir, it will be humanly impossible, at least for me, my lord, to go through the brief of this size, my lord, in one night or in one evening or 2 evenings. My lord, it's not possible.
My lordship is
and it's a
my lord is
complex.
keeping it tomorrow or day after tomorrow, my lord, on the 7th.
Very well.
Let you decide.
I am not that talented, my lord. So, my lord, I will take time, my lord, to have instructions.
Yes, then let the interim order be stayed.
No question.
Then you be ready with the instructions. Tell me that.
My lord.
By what time do you think you will be getting?
My lord,
the
I have to,
instructions be
for
ready?
the purpose of reading these briefs and files, because I must read every line of the brief so that I can render my best assistance to your lordship. But at least 4 weeks time must be given to me, my lord.
You kindly stay
My
the
lord,
interim order
kindly
and
see the
give
matter has
16 weeks.
That will be unfair to the court also, because
the matter has come on change. Otherwise, I would not have said.
well, it has come on change for you. You are not to be blamed.
No, the advocate on record also, he is absolutely a
But
stranger
then-
to the
then
matter.
This practice, this is not accepted. See, this matter, it is not that it is coming for the first time. This matter was there before the
My lord,
earlier bench.
Your lordship is
on
up.
second,
Your lordship
on
is
2nd
absolute-
April,
your
our
lordship is-
submission was completed on 2nd
At
April,
least
my
on
lord.
3 occasions.
Lordship is absolutely correct. My lord is completely well abreast of the facts, my lord, but we are not. So, my lord, kindly, but this is a complex commercial dispute.
My lord, I am objecting.
Having international ramifications. So, my lord, kindly consider that
4 weeks
aspect
will
of
be too much. I can grant 1 week.
1 week, my lord. It is not.
1 week is sufficient.
It is
Please,
not possible,
4
my
weeks
lord.
will be 4 weeks will be too much, because this is something which For what is there in this?
My lord,
that
there is
you will
only
not be
one
able to
civil
complete
revision
in
as
4 weeks?
and the
I
other civil
cannot
revisions
hear
are
your
purely
lordship
for
because of this
extension, my lord.
cacophony. I cannot hear your lordship. My lord, if my lord may kindly.
4 weeks will be definitely too much. 4 weeks time just to peruse the papers.
So, my lord, that is I am saying.
My lord, and he's enjoying an interim order, not making submissions, taking adjournments repeatedly.
Look, what
My lord,
question? What is
the last senior advocate also took, my lord, adjournments.
well,
Because he said,
I cannot say, and it will, I think it will be unfair to say, unfair to make any statement about a counsel who is not present to your lordship today. It will not be, it is absolutely unfair, my lord. And I cannot,
Fixing it after a week. Please come ready after a week.
but
No,
I have to
fair.
candidly, I will.
No,
If
I'm
your
very
lordship directs
sorry.
me, if your lordship directs me, I will, certainly, my lord.
But that is my learned friend's
I will
choice,
try
whether he
to,
wants
I
to
will
read
try
or
to,
he doesn't
one
want to
second,
read.
sir.
Mr.
Kind-
Chaudhary, please wait. Yes.
I will try to assist your lordship as much as I can, but I have my doubts whether I can do that.
No,
my
no,
lord,
I have full faith. I think you will be able to do.
no, I'll try to keep up, my lord, to
Yes,
live up to my lord's expectations. But I have my doubts because I have to read each and every line of this brief. Otherwise, I will be
Most of the papers are your papers only.
very well. But I have to go through them, my lord. I have to go through them, my lord. I do not have that talent.
1 week is sufficient. Why not 1 week?
Very well, my lord. My lord has given me 1 week's time. I will come back to your lordship. I'll try to get myself prepared as much as possible. But if there's, I am.
May I make one submission?
You are inaudible, absolutely inaudible, Mr. Chaudhary. I cannot.
Very well. So we are coming back to your lordship after 1 week.
After 1 week, I'm fixing it.
Very well.
Request, kindly, my lord, if my learned friend takes adjournments, please stay the interim order.
Yes. No question of, my lord. It's a peculiar circumstances, my lord.
No.
It's a peculiar, my lord. I want to file an affidavit. They object. If I want to file an affidavit, they object. There are 4 matters which
on
are.
the next occasion, Mr. If this adjournment is again prayed for, I may have to consider the prayer.
Your lordship will certainly consider.
Because interim order prayer will then have to be considered.
Lordship will certainly consider, but my lord will kindly record that statement, my lord, that they will. My lord will kindly record that statement that they will not rely on, or they are not relying on any of the documents which are beyond the records of the trial court and the first.
Yes, that's the law. There are 20 reported judgments.
My lord, kindly.
Mr. Chaudhary, learned senior advocate appearing for the petitioners, submits that the petitioners shall rely only on those documents which form part of the trial court records.
Grateful, my lord.
At the time of arguments. Full stop.
Yes.
Mr. Chakraborty, learned advocate appearing for the opposite party, submits that in case, a document beyond the trial court records is relied on, he would reserve his right to use an affidavit in opposition.
Grateful.
To the revisional application.
Grateful.
Full stop. As requested by Mr. Chakraborty, list this matter after a week.
So today is Tuesday. My lord, very well, my lord. My lord, next Wednesday will it be possible? Because
the 13th.
Very well.
Just a minute, Mr. Chaudhary. Let me see my.
Next Wednesday, my lord.
Let me see whether.
I'm grateful, man.
I may have fixed another matter. Then in that case, it will be different. কি ম্যাটার নাম কি এর এরকম নাম্বার লিখলে তো বুঝতে পারবো। When is the other matter fixed? The connected matter?
দু সপ্তাহ বাদে বলেছে
Thursday.
After 2 weeks. After 2 weeks. my lord. After 2 weeks on 30th, there was an order passed for after 2 weeks, which means 14th, around 14th. my
কি
lord.
হচ্ছে নাকি এগুলো?
14th, my lord. That's much later.
My lord,
Can we have it on 14 then?
very well.
My
Because
lord,
then
we are suffering and, my lord, may I submit this? We are suffering an interim order passed by a court without having any jurisdiction in the matter.
So, my lord, we are saying that
And my
we will
learned friend is, my lord, just deflecting the hearing. We have
I'm
completed.
I'm fixing it on 14th. On that day, we shall hear out both the parties then.
My lord,
14th, 1/4.
deeply obliged.
My
My
lord,
lord, will it be my lord's-
kindly take it up
Recorded
next week, my lord.
order
We
will
are
be
suffering an
considered.
interim order.
Order will also be considered, my lord, if that can be recorded in the order. my lord.
Let either you speak or let him speak. Yes, Mr. Chaudhary.
My lord, kindly consider next week, my lord, if it is possible.
14th is next week only.
My lord, no, it's, my lord, 14th is very well, my lord. I'm sorry.
We are on
My
5th.
mistake. My mistake. I'm sorry, my lord. I thought the week after. I am very sorry.
Great.
Let it be on the
Deeply
14th.
obliged.
14th is next week only. So
Please.
on 14th.
Yes, yes, on 14th. my lord.
Pleasure appearing with your lordship.
My lord, may we have a fixed time on the 14th?
2 p.m. 2 p.m. 2 p.m.
2 p.m. Grateful, my lord.
Pleasure appearing with your lordship. Great.
2 p.m. হ্যাঁ আরেকটা ম্যাটার আছে তো 2 p.m. একটাই আছে তো ওর সঙ্গে এটা অ্যাপিয়ার করে যাবে একই ম্যাটার এদেরই ম্যাটার
I'm grateful to your lordship.
আলাদা আলাদা অর্ডার হয়েছে তো আগে দেখে নিন আলাদা আলাদাই করে দিন ট্যাগ হয়ে যাবে ঝামেলা হবে আলাদা আলাদা অর্ডার
Item number 5, I am for the defendant petitioner. But the point is that, my lord, that my learned
senior friend starts, my lord. He had obtained an interim order and direction for service was given the as far as back on 9th of September 2025. Till date, we have not received a copy.
but,
On the last occasion, my lord, when the matter appeared under the heading extension, my learned friend informally prayed for also a copy, my lord. That is also not given.
somebody was representing
Yes, he was till today he has been not been served with a copy.
But- copy by.
We have served an affidavit of service.
But according to my advocate on record, my lord, the copy has been served, my lord, and affidavit service to that extent has been filed before your lordship, along with the copy, my lord, that has been served upon the.
No. It is served upon the artist hearing.
Fine.
May I just see once, my lord, the affidavit is copy है affidavit service? अरे दाड़ा
yes it appears that
My client has not even.
if his client, my lord, will feel for making
Today,
any
my lord, in the morning, my lord, he has confirmed from the client, my lord, sending and service, my lord, whether this has been signed.
94 grams wouldn't have been without the petition.
Lord, I do not know, my lord. Till today, my lord, my learned junior had confirmed with him, he has not got any copy.
Mr. Mukherjee, serve a copy.
Definitely. But only thing, very short point that my written statement I have prayed for. Now it is within the time, my lord, 90 days after 30 days is a High Court amendment.
Anyway, serve since he has not been served, I'll consider it as the next occasion.
Kindly keep it as same position, my lord.
Yes.
Because
Sure. Lord, copy. Very well. My lord, let the written statement be filed within a particular period.
but may I just indicate, my lord, only. But suit has been filed, but kindly mark some two dates, my lord. Because I want to show, my lord, that the time which, my lord, the learned trial has refused to extend the time is without, my lord, without considering the, my lord, extended provisions of the amendment of Order 6 rule, amendment of the written statement. Because why, my lord? I entered appearance, my lord, 25th June 2025.
Right.
Now, on that day, my lord, the court was pleased to grant me time to file written statement till 12/8/2025. Now, my 12/8, I paid for further extension because, my lord, another appeal is pending before this court. But court rejected. But that time, the, my lord, has not been expired. The 90 days has not been expired. But court, my lord, kindly see. But one
90 days, when did you receive the summons?
my summons, my lord, I entered appearance on 25th June,
June.
June.
So July, August, September.
September. Then August, my lord, the court.
August time had not expired.
No.
Not from the entering appearance, 30 days of receipt of the summons.
I'm telling, my 90 days plus, my lord, High Court amendment, your lordship
30
was
days.
High Court amendment another night, 30 days, total 120 days. But this is
That
within
is on showing cause.
that I have showed.
Showing cause. Yeah, anyways,
Very
you have
well.
shown cause, that is sufficient. Where are your causes? Where is the petition showing cause?
Yes, my lord. But kindly see my application.
Where is that? It's not annexed to the revision.
Yes, my lord, subject to correction, it has been annexed, my lord.
No, no. Not in my copy.
আরে দাঁড়া না তুই এসিএস করিস কেন পেজ 24
Page
24 my it is my handwritten if your lordship permit my lord, I can read for your lordship my lord.
Oh, this.
May I just read my lord?
No, no, I can read it.
তো যখন আগের দিন কপি চেয়েছিল দিসনি বা কেন বল ম্যাডাম হচ্ছে মামলা এখন
Date of read.
read তো
Taken it.
and my lord, if you lordship see the impugned order, I filed two applications. One is that my lord, to bring on record the order passed by this honorable court. Another application for extension of time to file written statement. The learned trial judge, my lord, kindly see that in the first paragraph, my lord, learned trial judge has dealt with my first application and says that it is not required to bring on record the order of the honorable court. Now, my lord, kindly see the last paragraph. On perusal of the records, it appeared that summons was served on the defendant on 8/5/2025. The statutory period for filing written statement is over, so the prior is time to file written statement is rejected. Now, 30 days, my lord, I have given the cause, my lord. Now, my lord, I received the summons on 8/5. Now, my lord, 90 days will come, my lord, up to my lord 8/8 August. Then, my lord, on August, my lord, I prayed for time. Now, my lord, another 30 days, my lord, High Court amendment, my lord, Calcutta High Court amendment, 120 days total. Therefore, my lord, with due respect, my lord,
That
court.
is discretionary. That is not a matter of right. 30 days is discretionary.
Very well.
Court has exercised discretion. Anyway, I mean, since Millard, I am
This
not.
revisional application is directed against an order dated August 12, 2025, passed by the learned judge
Ashish Kumar Chaudhary is appearing in this matter. I'm paying for just not today. And he is not present today. That's why I'm paying for not today.
What that?
My lord, I am from Visakhapatnam, and only for this case, yesterday I was appearing through video conference.
File this affidavit of
This one.
here online hereafter because nothing is required to file.
My lord, here, I am from Visakhapatnam. Here, I don't have proper internet also. From my phone only, yesterday I could able to somehow communicate, but I am not sure.
Why the will you be able tomorrow? Fix it tomorrow.
My lord, at least that stay for that seventh execution court may that date is there. So at least some sort of stay has to be there. 7th May, 7th ADJ, Barasat.
Tomorrow is 6th.
Tomorrow is 6th. So tomorrow again physically I have to come this court, my lord.
Are you leaving today?
My lord, I am waiting for this case only, my lord, and I am here from so many times.
Well, he is not present today. That's why I'm.
Today the case is there, right?
He's suffering from severe illness. That's why I'm saying high fever. Well, that's why I'm instructed. That's why I'm instructed to stay.
My lord, here the case is actually, I'll just submit for 2 minutes, my lord. Here, some interim maintenance order has been passed telling that I could not show any document of the income of the wife. But the point here is that I submitted a lots of documentation, which is already mentioned in the last interim order. And as per the guidelines of the Honorable
Will it be very difficult for you to stay till tomorrow?
My lord, it will be difficult for me tomorrow.
One day. It's for today.
My lord, I don't know when I will be able to come back to my office because this is the case. They are dragging it for so long, my lord. On 27th, that date was there. Again, tomorrow, I don't know, my lord. They may even.
27th it was without notice. 27th you moved
Okay.
expired.
Okay.
So on that day they are not supposed to be here because you served notice only after the 27th March order. So this is the first date when they are supposed to be here, and
Yes, ma'am.
I mean yesterday was the first date. Yesterday there was a resolution.
My lord, what I am praying, let's be some sort of stay on the impugn.
Say the maintenance. I can because maintenance you are absolutely not liable. Maintenance we'll have to consider on the after hearing.
My lord, there is a running maintenance in the DB case where I am already paying 20,000 per month. Last month also I have paid. This month also I am going to continue that. So even the opposite party, she is working now. She is having a monthly salary of 43,720 rupees. So which she has not disclosed to the court. So the fundamental aspect of this case itself.
I'm doing this, fixing it tomorrow. Tomorrow I'm making it clear that if you do not come, or if you pray for an adjournment, I'll stay here.
And my lord, my number should come from 8th of April.
It has come today. This, the petitioner is present in person. Affidavit of service filed today is taken on record.
already the firing range, my lord. 7 and 13, my lord. What more?
Correct the order, I am not admitted in. Moreover, one more thing which on the last document, because in your application also it is not your case that you are not a defaulter at all. You have not said so. That also I was searching for it, that if I could get one line. Don't say that you are not a defaulter at all. You say that she refused to accept rent after this training. Then what happened after that? If somebody refuses and still you don't pay, you have other avenue. Section 21 is there.
21 is there. Yes, yes, yes.
Don't say that you are not a defaulter, and yet you say it is without prejudice. It means there is admission. To me, that line, then I can consider it.
Page 16, para 5.
Page 16.
Yes, my lord, starts from page 15. If your lordship kindly sees page 16, para 5.
Yeah, but this is only up to 2022.
Yes, my lord.
Thereafter?
Thereafter, para 8, 6, 7, 8.
6, 7, 8 doesn't say it is defaulter. It is not a defaulter. Please see 6.
Yeah, the plaintiff receiving.
But after April 2025, the plaintiff refused to accept it. So after April 2025, when is the suit filed?
Suit was filed on.
I was considering that when filed
9, some 2020.
sometime in September, page 13. Jurisdiction is sometime in September. So from the pleadings also, at least from April to September, you are a defaulter. So that admission is not at least no admission at all. Just say no, there is no default. If there be any, please admit it. That is something else.
That will not cannot be improved.
Has to be on the basis. How will I say that becomes difficult?
This is what. Grateful.
এই তো চলে গেল, এই তো ছিল, এই তো অবস্থায় ছিল। 8 my lord, I am for the petitioner. He was there.
You appearing for the opposite party.
Madam, how do you have jurisdiction?
Lordship, I am led by my
Does not
senior.
have jurisdiction, then
Lordship, kindly allow me a passover, Lordship.
let him come.
My lord,
Next.
I appear for the petitioner. I am for the opposite party wife. My lord, in last occasion, my lord was to my lord's direction, my lord. The matter was referred to mediation. We have also given letter to the mediation section, my lord. I have came to know from my other side, my lord, that mediator has been appointed, although proceeding has not yet started, my lord. This is the position. I have informed that the mediator has been appointed, my lord, from the center. Yes, it should be adjourned, my lord. The interim order is till the end of this month, my lord.
Finally submitted by the party that with the order dated March 31, 2026.
Eight, my lord, I am for the petition. Eight. My lord, may I be permitted?
Yes, Mr. How does the court have jurisdiction?
Court did not commit any wrong. I am telling. Initially, when the suit was filed, it was value of 200. My learned friend pointed out by filing an application 711, the suit has not been properly valued because 5,000 license fee. So in view of section 7 subsection 6 of the Code Fees Act, 1 year value, 1 year assessment, 5,000 into 12, 60,000.
But if you have wrongly valued it, then in that case, does it give jurisdiction to the court to assure?
If the suit is value of 200, then learned
Value is 200.
civil court has jurisdiction.
But if your valuation is undervaluation, if you have undervalued it,
Yes.
then in that case, the court would not have had jurisdiction. Merely because you have undervalued it, it puts up a show of valuation of court did not have.
200 court have jurisdiction.
200 is undervalued.
And
Undervalued. Then in that case, can court receive it?
Well, when I file an application 617 to cure the defects, court can,
At the threshold, court has a duty also whether I have.
but I have judgments also, say, Supreme Court and Punjab Haryana High Court, that court can, at that stage, court can allow the amendment application to cure the defects, to insert the appropriate valuation of the suit.
If the court has jurisdiction to receive the plaint first, suppose I receive a plaint.
200?
It is valued at 1 rupee. I will not go by your valuation. I also have a duty as a court to see whether in terms of the pleadings in the plaint, the valuation is proper or not. If I find that no, the court is undervalued, then in that case, and if it is properly valued, I don't have jurisdiction. I will not be able to receive the plaint.
If the plaint is valued as 200, court have jurisdiction.
That is your valuation. That is what I am saying, Mr. Ghosh.
Yes, that is my valuation.
Whatever may be your valuation, the court has a duty to see the actual valuation. If the court on actual valuation finds that it does not have jurisdiction, can it allow you to correct it and then retain the
Undervalued, my lord, court has the jurisdiction, my lord. I beg to differ the losses of
Yes, why not? If a suit is for eviction of a licensee,
license.
and according to your own plaint case, the licensee is license fee is rupees X, 12 into X comes to a certain amount for which the court will not have jurisdiction.
No, court have jurisdiction.
Court will not have jurisdiction if you take the license fee for
60,000, court has jurisdiction.
which this court has jurisdiction.
Yes.
then it doesn't have.
My lord, there is 3 prayer. My lord, once kindly come to the prayer.
Earlier, Lord Civil Judge, it was 30,000. It has been increased to 60,000.
Then which other jurisdiction did not?
My lord,
it tax peculiarity?
my lord, I'm coming. My lord, once,
Come later on. Come
my lord, kindly come to page 30.
Yes.
The prayer of the plaint. There are 4 prayer. One for eviction of a defendant for recovery of possession, recovery of revocation of licensee, and recovery of khas possession of the suit property. For this, as your lordship understand, as per section 7(6)(b), 5,000 into 12, 60,000. Thereafter, my lord, for passing decree for means profit, I'm not making any valuation with regard to this. I'm not making. Thereafter, degree for permanent injunction, there should be at least rupees 20 is the valuation. Whenever that
I have
comes,
made an application for amendment deleting those paragraphs.
How?
With this prayer at the threshold, if I don't have jurisdiction, I will not have jurisdiction to receive it. How can I delete it? I can delete it only if I have jurisdiction to receive it.
I am not, by amendment, I have deleted my prayer for permanent injunction and win profits. Initially, suitor's value is 200.
That is your valuation.
Yes.
Not repeat that again and again.
Yes.
Your valuation is immaterial. The court will go by whatever the court will be actual valuation. If it is undervalued by you, by putting it at 200, the court will not assume jurisdiction if it does not have jurisdiction. Now here, the court would have had jurisdiction if it was within 60,000.
Yes.
My lord.
Now going by the averments in the plaint, the license fees for 12 months will be 60,000.
Yes.
But that is not the only prayer. There is a prayer for injunction.
That prayer has been deleted.
That has been deleted later on. The court has to receive the plaint first. If I don't have the jurisdiction to receive,
Hello, kindly
kindly
see the contents of the amendment application, the schedule.
Amendment application will come into picture only if I have jurisdiction to receive. Exception is the first, the threshold.
Initially, court has registered the suit because
that is where I am. The court could not have registered the suit then. At the threshold.
At that point of time, which was value is 200 and 100.
That is your valuation.
Yes.
We are repeatedly saying this. Please don't repeat that. 200 was your valuation. Your valuation is nothing. The court has a duty to scrutinize the plaint and see whether it has pecuniary jurisdiction to entertain it. I may file a suit before the learned.
My lord, I am asking myself, can I not make a prayer for correction of the defects, cure the defects?
You can make a prayer for curing the defect before a court which has jurisdiction. You cannot make a prayer for curing the defects before a court which lacks jurisdiction. Here is a case where you file a claim undervaluing it. and then you want to cure the defect. You could have.
My lord, I am reading out the 711. 711. My lord, plaint shall be rejected in the following cases. B, where the relief claim is undervalued and the plaintiff on me required by the court to correct the valuation within a time to be fixed by the court fails to do so. Well, Rule 11.
Right, but then the court should have jurisdiction first. Court should have jurisdiction first.
Suppose, my lord, in terms of small b of Rule 11, the suit is undervalued. Court may direct the plaintiff to put the correct valuation by of amendment.
সেটা তো jurisdiction থাকলে
Show me a case where the court lacks pecuniary jurisdiction and the court has accepted the plaint upon undervaluation, and then the court allows amendment.
I beg to be excused for repeating my submission. But kindly turn to the plaint. Page.
Sir, your 200 is not cutting ice. Your 200 is your valuation.
My valuation.
Your valuation has nothing.
If it is wrong, but court has jurisdiction to entertain the suit.
That is where I am. The court will have jurisdiction to entertain if even after overvaluation or proper valuation, court would have retained jurisdiction. For example, suppose this was undervalued at 200, even after properly valuing it, the court would have retained jurisdiction, then in that case, amendment would have been allowed. If after properly valuing it, the court lacks jurisdiction at all, then in that case,
60,000 court has jurisdiction.
it is not only 60,000. With these prayers at the threshold, it did not have. Suppose on the first day, the court had found that before the application under Order 1617 having come in, the court would have returned the plaint. Would have returned the plaint or not?
Initially, on the day of presentation of the plaint, my lord, 200 and 100. My lord,
then the court is failing in its duty. There are judgments, Mr. Ghosh, you also know that the court always has a duty to first scrutinize the plaint.
well, kindly consider small b of the Rule 11.
That I have considered. That we'll have to explain then that in what circumstances that can be invoked. That can be invoked only if after proper valuation also the court has jurisdiction. If after proper valuation also the court finds that...
Well, there is a judgment of the Supreme Court also to that effect.
That is recent, I know. As recent as maybe 15 days or 20 days back. I've seen that it cannot be rejected until opportunity is given to correct. But even if we at the threshold, the court, there are situations you have to see that case. Whether in that case, prior to the undervaluation, if the undervaluation is brought to a particular limit without changing the prayers, this is one thing to say that you properly value it. It is another thing to say, don't properly value it, strike off certain prayers.
Yes, start. Well, Lord, one judgment is that 2006 Madhya Pradesh, my lord, effective amendment would entail in outside jurisdiction of the court, which it originally had. Proper court would be allowed to amendment and then return amended plan for presentation before the proper forum. Well, kindly see this.
That is not applicable to the case because that is the reverse of your case. That is that there are other judgments.
If your lordship is fine, the 60,000 sought to be amended by amendment applications. Court may return the plaint. Court may direct the plaint to have
returned at the first place, and you could have filed it after visiting the prayers. That would have been the best course because this at the first stage it should have jurisdiction to receive the plaint.
Yes.
It will have jurisdiction to receive the plaint if upon actual valuation it has, not on your valuation. You may write 100 rupees. The court will not go by what you have written. The court will apply its mind and see whether it is properly valued or not. If it is not properly valued, then the court will either return it, or if the court finds that upon proper valuation also, the court may still have jurisdiction, court will ask you to amend it. But you have not done that, and that is not what is there in Order 711. See.
Small b.
Small b.
Well, small b, small similar.
correct the valuation.
Yes.
Correct the valuation. What you have done? You have amended the plaint, corrected the valuation, and amending the plaint are different things. Mr. Ghosh, let us understand this. Yours is at 200. Now the court asks you to correct valuation. What will happen? The moment you correct valuation, it goes beyond the pecuniary jurisdiction of the court. Yes, of course.
No, well, kindly consider the amendment, plain amendment application.
There are
Kindly
four-
consider for a moment.
Prior to the amendment, the valuation part will come. Order 7.
Prior to the amendment, court has jurisdiction.
Prior to the amendment, court did not have jurisdiction because that is your own valuation. We have repeated it 20 times now, Mr. Ghosh. 200, everybody now has got it embedded in everybody's
So many decisions that court at the
200 is your jurisdiction, your valuation. 200 is nothing for the court. The court will have to assess the actual valuation on the basis of the pleadings. If the court finds that the plaint is undervalued, it will ask you to correct the valuation. The moment you correct the valuation here in this case, let us assume with the prayers, what the court cannot ask you to strike out prayers. It is not within the court's jurisdiction. It is your, I mean, whatever your desire to keep whatever prayer you want. It will be the court's desire to strike to keep the suit at proper values. What will happen? The court will say, you please correct the valuation. The moment you correct the valuation, it will be 60,000 for eviction and something for permanent injunction. Because the plaint contains.
Well, 60,000 sought to be, well, 60 is inserted by amendment. I mean, so order says rule 17. Order says rule 17 when it was allowed. Well, 60,000 was inserted by amendment of the plaint. Initially, 60,000 was not valued.
Plaint was not there.
No.
My lord, it is the preliminary plaint.
Well, kindly see this, my lord. Page 17 starts from page 17. Page 18. What your lordship is observing is correct.
Now, my lord, come to page 19,
Yes.
para 1.
Have valued it for eviction at rupees 100.
Yes.
It could not have been. It could not.
It may be mistake on the part of the.
So therefore, it may be your
Mistake can be corrected. I have
can be corrected. Then in that case, the court will ask you to correct it.
Court is court.
If the court asks you to correct it, it goes beyond the jurisdiction of the court. Because if you correct it and you make it 60,000, it will be 60,100.
That well, kindly see the entire contents of the schedule of the amendment, my lord.
Your amendment, why are you, Mr. Ghosh, putting the cart before the horse? Your amendment will come once the plaint is there.
Well, 60,000. Well, if a lawsuit observe the 60,000 correctly observed, then court has jurisdiction. If the 100 rupees 100 valuation, if it is added, court has jurisdiction. I have sought an amendment to delete that prayer.
Mr. Ghosh, the court will allow the amendment application only if the court has power to receive the plaint. We can go on addressing this for 100 hours, but we will reach the same conclusion. For allowing an amendment, the court first has to have jurisdiction to entertain the plaint. How can I allow an amendment if I don't have jurisdiction to entertain the plaint?
Well, lordship,
Valued at 60.
I bow down to lordship. Lordship's observation is that if the suit is undervalued, court has jurisdiction.
No, that is not my observation. My observation is if the court is undervalued, court will ask you to correct the valuation. The moment
court has.
Mr. Ghosh, let me complete now. We are repeating the same thing again and again, unnecessarily wasting time. The court will ask you to correct the valuation. While correcting the valuation, the court will not say that you correct the valuation by amending the plaint. While correcting the valuation, you just correct the valuation on whatever prayers are there. The prayers are 60,000 plus 100. It will be 60,100. The moment you correct it, it goes out of the jurisdiction of the court for which you have your MP court judgment. And there are Calcutta judgments also. Now, the moment this happens, the court loses jurisdiction. It will return the plaint to you under Order 7 Rule 10. That is the only remedy that is available. If you wanted this, you could have filed an application under Order 7 Rule 10, taken the plaint back itself, filed it in the correct court, or you could have then.
Subject to your lordship, sir, I cannot make an application 710 because the entire amendment is allowed.
That is wrongly allowed. That is why he is here. That is wrongly allowed. He does not have jurisdiction to do it. If he lacks pecuniary jurisdiction, he could not have entertained the application for amendment. You please consider this. I am saying this with sufficient understanding of what I am saying. Please go through the provisions once again. Order 7, Rule 11, under valuation, it speaks about correction of the valuation, not the amendment of claim. You cannot correct the valuation by amending the claim. You have to correct the valuation by correcting the valuation. By reducing prayers or by adding prayers, that is not under correction of valuation.
The relief is undervalued. The plaintiff on being required by the court
To do what?
to correct the valuation.
Correct the valuation, not to amend the relief.
But the court did not ask the plaintiff to correct the valuation.
Court should have. That is why he is here. That has been our understanding from 12 when we started the matter. That is what I have been trying.
And in his statement, he said nothing with regard to the valuation.
This is one point of law. If you want to address me, please address me on this, because this is something which is important. At the threshold, ought to have applied its mind to the claim and seen whether it has jurisdiction or not. Merely because you say it is 200, 2 years later it might come.
Then my lord, I have to address properly.
Come back whenever you want.
My lord, there should be a stay of the proceeding. My lord, to date 7th is the date fix.
For hearing of the Order 7 Rule 11 application.
Order 7 Rule 11 now amendment is allowed. Order 7 Rule 11 will also be
Infractions.
Infractions.
Then my lord, kindly fix the next day, my lord.
When you tell me.
10th or 11th. 10th.
10th of this month. May. My lord, I would not be here because I'm praying for apology, my lord. My wife going through the cancer. So from 9 to 12, I am not here.
9 to
12. I go to Bombay, my lord.
Then my lord, 15th or 16th.
15th is
15th holiday.
Saturday.
15th.
Shooting 19 तारीख से
15th is Friday.
15 is Friday, my lord.
Divisional application. Again. Order that you are checking.
My lord, last
2026.
I'm for the opposite.
And I am for the petitioner.
They have challenged both order at a time, my lord. One dated 17/1/20. I am just 2 seconds. One dated 17/1/2026, another dated 12/7/2024. Both order at a time they have challenged. I don't know whether it is permissible under the High Court's rules and order, my lord. Whatever I this my
12th of July 2024's order, Lord, this is a suit for recovery of possession, Lord, under the Transfer of Property Act. Lord, I filed an application under judgment on admission under Order 12 Rule 6. Lord, that principle that if the landlord-tenant relationship is admitted and if the right of the tenant is not protected within the ambit of the West Bengal Premises Tenancy Act and service of notice is admitted, that the court is entitled for passing a judgment on admission. Lord, the defendant appeared and filed his written statement. Lord, so far as the relationship of landlord-tenant is concerned, Lord, he has admitted. Lord, so far as the service of notice is concerned, Lord, he has given a reply to that effect. Lord, the third issue, Lord, which is very vital is that, Lord, I have stated in the plaint that the rent is rupees 14,000. Lord, they have vehemently denied that it would be otherwise rupees 7,500. Lord, even going by their admission also, Lord, they are not protected. Lord, this is my simple contention. Lord, going by the admission of rupees 7,500, Lord, that would also come outside the purview of the West Bengal Premises Tenancy Act, section 3, E subsection 2. Lord, it is in not in Kolkata Municipal Corporation, it is Vidhannagar. It will be 3,500 above. Lord, the court, while passing the impugned order, passed an erroneous observation. Lord, my lord would kindly comes to the order impugned once. Lord, this is basically that the chapter 13A of the same principle applies here. Lord, order dated 12th of July 2024. The last page. The second last page of the revisional application. Lord, the
24 order, why have you challenged?
Para 19. Para 19 of my application, Lord, I have stated. Lord, although the limitation is not sufficient cause, Lord, absolutely. Para 19. Lord, that Bitika Mojumdar's judgment, Lord. Because, Lord, order 12, rule 6, Lord, this is a speedy trial. Lord, we were of the opinion, Lord, that the suit will be expeditiously, Lord, disposed of. But any event, Lord, they are taking, Lord, adjournments and the Lord, learned court is. Lord, so, Lord, not 2 years, Lord, 1 year, 8 months. Lord, the last page. Lord, it is to be assessed, Lord, the portion of the paragraph. It is to be assessed if the plaintiff's claim on judgment or admission passes the test laid down. Thus, it is necessary to look into the facts of the instant suit which has been filed by the plaintiff for recovery of possession. It is submitted that the plaintiff were lessee in respect of the suit property, the defendants were licensee jointly by the plaintiffs. The defendant paid rent of rupees 7,500 per month to the plaintiffs, which was enhanced to rupees 14,000. The plaintiffs determined the tenancy by serving the notice. However, the defendants failed to vacate the suit property, thus the present suit. This was the plain case. At this juncture, it is necessary to produce the written statement filed by the defendant. It appears therefrom that there is no clear, unambiguous, unequivocal or unconditional admission of service of notice by the plaintiffs upon the defendants. On the contrary, the defendant submitted that the notice dated is not in accordance with the law. Also, the real
Evicted. What is the admission?
Lord, the admission is that, my lord, they have admitted that they have received notice under 106. My lord, the learned court admits that my lord,
The admission from that pleading.
my lord, I'm showing my first from the impugned order ones. My lord, they have replied to that notice. My lord, kindly, my lord, comes to the admission, which is at page number 33. My lord, clause B. By an agreement dated 15 June 1990 between Sholil Kumar Sur one part and Shiv Kumar Ruya and Arun Kumar Ruya on the other part, the Shiv Kumar Ruya and Arun Kumar Ruya were inducted as tenants at a monthly rental of rupees 2,200. The agreement dated 15 June 1990 continues to be in operation inasmuch as the same has not been determined at any point of time. Accordingly, the parties are bound by the agreement and liable to take steps under the law if at all possible. The plaintiffs have not taken steps in accordance with the law. The defendant states that none of the conditions that may exist for such. This was notice. Notice.
But even if they have received, how can they be evicted merely on receipt of notice? Suit has to proceed. It cannot be a.
There was a judgment of our division. The moment the landlord-tenant relationship is admitted and 106. It invites no other consequences but to pass a judgment on admission. The unqualified admission starts from para E. First, the relationship of landlord-tenant has to be admitted. He admits the agreement. Thereafter, he admits the quantum of rent, rupees 7,500.
Paragraph E, please read. Purportedly entered into. It is not an unqualified admission. And thereafter,
Even
is not valid.
Is not valid. The defendant states that he is denying, but he relies on a letter that you please take rent by virtue of this agreement. That letter is very important.
That is a matter of evidence.
That page 86, kindly 6. 86.
This has to be proved in evidence. If it is not a part of the pleadings, admission has to be from the pleadings.
Along with towards the pleadings. This has been recently reiterated.
Without proof. Somebody should that becomes
from paragraph number 35, 37. It is against our Calcutta High Court judgment. But para 37 is very clear.
that document to be proved in evidence. It cannot be merely.
It was not proved, It was on the basis of the admission, the court given a decree and it has been affirmed.
What kind of admission was there?
The admission was that, in case of a 2G matter, the moment, on paragraph number 17, the only, the defendant admitted that he inherited the tenancy from his father.
That is sufficient. That is a critical admission in the pleadings itself. You cannot just exalt the status of this kind of.
Here, it has also been admitted.
Just, he has denied it. He has said it is not valid. No right can be claimed under this agreement.
But on the same breath, he relies on a letter, saying that see this.
That relies on that letter. So
the reliance on the letter is page 86. 86.
The letter is the.
If anybody now, then in that case, suits will be difficult. I will bring a letter saying that this is your admission, this has to be then. This is not.
Milord, in that event, Milord, then Milord, I would take your lordship, Milord, to the next order.
Yes.
Not in any event, Milord, this would have, Milord, suffice my case. That the 17th of January 2026. That this is very important. Milord, I say 14,000, they say 7,500. Court came to a finding, you are not entitled for market rent, only 7,500. Milord, my lord would first comes to my application, Milord, where I have stated very detailed that on the same self property, Milord, I have inducted, Milord, the tenants. Milord, one of them who is the branch manager of a UCO bank, Milord, I am fetching certain amount of rent. Milord, kindly direct me to pay that amount of rent. Milord, that application, Milord, my lord would kindly first see, Milord, for the convenience of the court, Milord, I have framed one, Milord, tabular statement. Page 170. 117. Milord, before coming into 117, Milord, my lord would first takes the scheduled property once. Page 27. Page 27. Milord, it is the scheduled property of the plane. And my lord would kindly takes note of the measurement of the suit property once. Followed by, Milord, page 73.
Page 73.
3. Milord, which is the agreement. Milord, which both parties we are relying. Milord, again same 1960.79 square feet. Milord, thereafter, my lord would come to page 117 once.
Yes.
But there are, Milord, a statement has been made that my lord would first take, Milord, a document, an unregistered leave and license for the year 23rd of May 2018. I have given. Milord, what was the rate of rent? Milord, it was rupees 21.05 square feet per month. Milord, what was the area? It was 760 square feet. And Milord, the year of agreement has been given. Milord, the very second, Milord, on the same self property, Milord, again 23.68 square feet. And Milord, on the subsequent pages also, Milord, I have given those. And ultimately, Milord, paragraph 32, Milord, I have made a conclusion. That see, that from June 2018, Milord, page 119. 19, para 32. Milord, I have stated that from June 2018 to May 2021, it will be rupees 21.05. Milord, this was like the pattern. And ultimately, Milord, I have said that let me give rupees 21 per square feet. Milord, for the ends of justice. Milord, in this event, Milord, the learned trial court, Milord, declined to give, Milord, the market rent. Although, Milord, the court has come to a finding that the relationship is admitted by the defendant. My Lord would takes the second part of the impugned order dated 17th of January 2026.
Yes.
Milord, first, Lord, the court has stated it is settled position of law that when relationship of either landlord or tenant or lessor or lessee or licensee is admitted by the defendant is liable to pay occupational charges. However, this court is not inclined to direct the defendant to pay mean profit or occupational charges at the prevailing market rate in excess of contractual rent during the pendency of the suit. Also, upon considering the contention of the plaintiff and written statement, the plaintiff's claim for mean profit on and from 1st January 2019, as well as the interim petition, is to be decided on disposal of the suit, since the parties are yet to complete their evidence, and thereafter he has given 7,500. Lord, mean profit is something different. Occupational charges is something different. Lord, mean profits can be given when there is a decree of eviction. Lord, so far as this occupational charge, commensurate at the current market rate is concerned, this has to be given because prima facie the defendant is occupying the property. It is in a posh location in the Salt Lake for about 1,960 area. And moreover, it is on the ground floor. I have shown those documents which are on the first floor and second floor. My lord would know, the ground floor fetches more rain in comparison to first floor and second floor. In any event, on first floor and second floor, I have make an average and directed that let me give at least rupees 21 per square feet pending hearing of my eviction suit. Considering the issue laid down in that money square judgment case. That judgment, I have also relied. The court has not dealt with, not even distinguished that also. In the very first impugned order, my lord would see, I have relied upon that judgment also. May I place those judgment first? 2025 SCC online, Calcutta.
Where has he admitted 7,500?
7,500 he admitted. That page 34 E.
It is not valid and that's not admission.
And in any event, in the open court, I was present, the learned judge asked, what would be the rent? He says 7,500 also. It was like that you cannot occupy the property for a without paying something.
Yes. Show me from Money Square where during pendency of the suit it can be done.
Lordship, Money Square, kindly takes para 41 clause A. Para 41, what was the issues, frame? Having carefully scanned the arguments of learned counsel for the parties, I find the following issues.
Yes, B.
B. A2 and B. Thereafter, para 47. The findings start. Enter the judgment of the High Court has been decided along with Atmaram properties. Para 47, the judgment of Vijay Kumar Monish Kumar has been held. Pre-suit, pre-eviction, market rent can be given. Your lordships has reiterated the entire judgment. Thereafter, on paragraph number 48, the findings.
48, yes.
48. We therefore see in the above case, the Honorable Supreme Court directed the tenant to pay occupational charges at a higher than the contractual rate, even at a pre-eviction degree stage. Indeed, there would be nothing unfair or inequitable in issuing such a direction if the contractual rate, which may have been agreed upon decades ago, if is found to be absurdly low compared to the current market rate of rent.
Got it.
48, 49, and 50.
Yes. Yes, sir.
I will file a affidavit in opposition.
This stage in the civil revisional application, what affidavit in opposition? It's on the pleadings which is there before the learned trial court. I'm not considering anything new, fresh.
My lord, give me 2 days only. Only 2 days. Only 2 days. I'm not very PPM, my lord.
Very well. Kneel in this revisional application assails 2 orders.
Correct.
live in the same position.
Yes, yes.
Lordship, may I be permitted to place the matter in person? My affidavit of service, Lordship. Didi to check.
I am appearing for the opposite party.
My grievance, Lordship, is twofold. One is the order that I have assailed, the operational part of it, which has denied me some reliefs that I've sought for, and the other part is the conduct of proceedings. So this is an Act 8 case, which was filed on 17th May 2018, and it is still going on. And there are phases in this proceedings, Lordship. In the first phase, the opposite party was not complying with any visitation order, and then I had to come before this honorable court. And if I could take your Lordship to page 135, on 2 counts, my lord, she has been held guilty of contempt of court. She was being committed to 7 days imprisonment, and then, keeping in mind the welfare of the child, she has been let go under final warning. So Lordship takes page 135. That would be CPAN 409. It starts there, and then there are 2 orders, my lord. That first order is dated 13th August. That is on page 139. And the follow-up order and the follow-up order was on 16th August. That starts on page 142.
This is the subject matter of this divisional application.
Let him conclude. Yes.
The conduct of the party
Yes,
is,
next.
Lordship. If Lordship takes up page 143, she has been held. The contempt. If Lordship takes the 3rd paragraph, as such, the contemptor is held guilty of contempt of court and by willful and deliberate violation of the aforementioned orders. In the next page, keeping in mind, as I place before your Lordship, the contender would be committed to 1 week's imprisonment. That was stated. And then she has been warned not to repeat her contumacious ways. That's the first part, Lordship. In total, 4 contempt proceedings had to be initiated just so that I could have access to my son. Now, the second part of these proceedings before the learned trial court, my lord, was delaying the proceedings. So first was outright refusal to comply. When she was held guilty of contempt under specific warning, then she started delaying the proceedings. In total, Lordship, 55 adjournments have been granted in these proceedings since institution. The Section 12 application for interim relief could only be taken up and disposed in the year 2023, 5 years after it was filed. I have annexed that order, Lordship, the order that I subsequently have sought for revision. That is Annexure A, page 23. Lordship sees the date. That's 12th April 2023. Filed in 2018, disposed 2023. Now, while disposing of this application, Lordship, I had made certain prayers. Weekend custody, access to my son's school, and so on and so forth. Now, Lordship comes to page 24, the second paragraph from the bottom, page 24 of that order, my lord. Internal page 2, running page 24. The court records my educational qualification and so on and so forth. I'll pause here for a moment, Lordship. For 8 years, I have no access to my son's school. I do not get access to my son's school, and I have no direct knowledge about my son's educational whereabouts. And in the meantime, he has already lost a year of schooling. So that has...
He has
lost a year of schooling.
Why?
In order to get my name removed from the school records, behind my back, my son's school was changed, and he was admitted to another school. afresh. These are all part of the evidence that the documents that I've exhibited. And it will be clear, Lordship, that my son was promoted, suppressed, school changed, false affidavits filed, and so on and so forth, Lordship. I'm not on that at this point. So this is something I've been fighting for. Then, Lordship, the court records certain submissions, allegations, counter allegations. The court comes to the conclusion that nothing adverse has been found against me. And then the court goes and gives me 1 overnight custody per month, taking my son to my residence on Saturday, of the 4th Saturday of the month, and returning him the following Sunday, and 1-day visitation. And some interim on interlocutory reliefs has also been granted, son's birthday, puja vacations, and so on and so forth. Now, this order did not give me any relief in respect of access to education or vacations, and so on and so forth. So I come up before this honorable court. So that would be, Lordship, page 28. So I come up before this honorable court, challenging this order for the reliefs that has not been granted to me, as well as, Lordship, challenging another order where till that point in time, the opposite party had not filed her written objection to the main matter in order to drag the proceedings. So I challenged both, and while disposing of CO 2501 of 2023, Lordship, video order dated 12th October 2023, if Lordship takes up page 29, yes, the coordinate bench, Lordship, the petitioner pays for further direction, allowing him to have interim visitation every weekend and on school holidays. So these prayers were considered, medical checkups, all the prayers that I had made before. Then the last paragraph with regard to the prayer for access to the school, this court is of the view that when the father is given liberty to meet the child at the residence as and when he pleases, there is no reason for him to have further access to the school. Because this order has not been assailed, maybe, I'm at peace with this. But I appeared in person there as well. I know what fell from her ladyship's, that given the conduct of the opposite party and the kind of prayers that I made, then she moves on to make 2 very critical mandatory directions that Lordship will get. The penultimate paragraph, Lordship. With regard to the order dated June 23rd, 2023, this court mandatorily directs the opposite party to file written objection to the Act 8 case within a week after reopening the court after puja vacation. Copy to be served in advance. Lordship sees it. The learned court is directed to dispose of the Act 8 case within a period of 6 months mandatorily from the date of communication of this order without granting any adjournments. So this was, and because of such strong directions, I was under the impression that this will get done and it will be decided on merit. So this is 2023, Lordship. This does not get done. I'll show from the orders, why it couldn't be done. Then I come back again that this order is not being complied with. Next year, the court reiterates these directions. That was in 2024. And now we are in 2026, Lordship. No end in sight. So my evidence could be completed only in two years. I was cross-examined on 18 occasions. I'll show from all the orders from the learned trial court, Lordship. I have also made a table of adjournments. I've annexed that. Lordship could see the day-to-day proceedings, how it has transpired. The opposite party still hasn't filed her DW. My evidence could be concluded in December. Now, given how the proceedings were being conducted...
Affidavit of evidence in chief has not been filed by the opposite party still?
Yes, yes. No. He doesn't have instructions by the opposite party.
Affidavit in chief.
By the opposite party.
That's by you, by your client.
By your client, my lord.
If Lordship takes up the Lordship will file in the impugned order, Lordship. If Lordship takes up the impugned order, the last page, Lordship will find 2/23/2026 for DWID necessary order. This is after the last chance was.
When is the next date for DW?
The next date
On 20th of March, what happened?
again adjournment. I can hand over the server copy, Lordship. The same.
Didi.
Again another adjournment.
Kindly come to at page
But
58.
she couldn't file. The court was not there. The learned presiding officer was doing SI. Nothing prevented her from filing the DW, but taking advantage of the proceedings, because a court is never vacant, Lordship. Lordship is aware. There's always a court in charge. Now, if Lordship takes up
tomorrow is the next date on which she is supposed to file. How long will you take to cross-examine her?
That depends on Lordship, because in the problem with this matter is Order 16 has not been exhausted. So I don't know how many witnesses she'll come up with.
How many witnesses do you have?
My lord, I have to take instruction, my lord. Kindly, my lord. I shall file affidavit in opposition in this matter.
Question, out of question.
My lord,
out of question, sir. Affidavit in
petitioner
opposition
has
is out
come
of question.
before you, Lordship.
Very well. We'll decide it on the basis of the records which are available and which form part of the trial court records. We'll decide that no
my
question
lord,
of
being
affidavit in opposition.
agreed by the order, impugned order
I have
dated
seen it,
10
sir. I have seen the conduct.
2026. My lord, kindly see page 858. Against which order my learned friend has
I've
come
seen the
before
order.
your lordship.
I've
File
seen the
this revisional application.
I've
It
seen
is
the-
not for expeditious disposal.
Not required. That the court is has power enough to pass even
Yes,
without
yes, my lord.
without a
My lord, I
challenge
bow down.
thrown to it.
My lord, kindly see at page 58 the impugned order.
Yes.
The impugned order, my lord. There is no error in the impugned order.
Why not?
Because, my lord.
Why not? The impugned order proceeds on the premise that the order already stood modified. What happens in the changed circumstances?
Exactly.
What happens to the subsequent events? Once an order is passed, is it an order for good?
My lord, coordinate bench, my lord.
There were other things also in the
has
order.
already passed the order.
Very
and
well.
it has been complied with.
There were other things also in the order. The order also said that it should be mandatorily done within 8 months. That was also the command.
But if court is not available, my lord.
Court was available. He has placed.
It's
He
not
has,
my
he
lord.
has placed charts where you have taken at least 10 adjournments.
My lord, I can take Lordship through the orders.
My
Lordship,
father, my lord, is seriously bedridden. And my mother, my lord, both are
Lordship
senior
takes up
citizens.
page-
My father
Lordship
is
takes
now
up page
my lord,
32.
82 years old.
Lordship takes up page 32, Lordship.
Because if you can carry on with the suit, then in that case, the other orders for visitation and all those orders can be passed.
And
If you want to carry on for the suit for the next 5 years, you can carry on with the suit for 10 more years. Interim custody will be granted. Then in that case, you cannot deprive the father in this way.
Definitely, he is in, my lord, pleasure, my lord, getting custody on all holidays, at weekends.
He also he also has
He's
similar
not
right
submit-
over the
he's
son.
not-
My lord, he is minor
as that
child,
is
my
yours.
lord.
My friend is not submitting
my lord,
under instructions,
my lord,
Lordship. He's
kindly-
making
kindly-
erroneous
kindly-
submissions.
Kindly see the impugned order, my lord.
And
May I
why
read,
should
my
the
lord?
school records? Why should the school records not reflect the father's name? Which law says that the
this
school
court,
records will
the
not
coordinate
record?
bench has given a finding. This coordinate
That was
coordinate bench.
that was in the facts of that case when the court said that it should
Same,
be disposed of.
facts and circumstances. There is no
It was
there
it
is
was
no
to be
change
disposed of within 8
circumstances.
weeks, 8 months.
There is no change circumstances. And kindly
There is a
see
change
the
circumstance that I will observe.
kindly see the impugned order, my lord. May I read the impugned order against which my learned friend has come, my lord.
Please read.
My lord. The petitioner is present in person by Hazira. The respondent files a petition praying for time for
No,
evidence.
don't read the entirety of it. I have read it once.
Yes,
you read
yes.
the relevant portion which you want to
bottom
show.
portion. Yes,
Yes.
the operative portion.
Yes.
By an order dated 12/10/2023 in CO number 2501 of 2023, the Honorable Court has been pleased to disallow his prayer for permitting him to access the school of the child. His prayer for interim visitation on every weekend has been turned down. It is thus found that the relief which is sought for in the instant petition has already been addressed by the Honorable Court in the order dated 12/10/2023, passed in CO number 2501 of 2023. It is therefore, my lord, we should go to the order, my lord, dated 12/10/2023, passed in CO number 2501/2023. It is therefore found that the modification of the order dated 12/4/2023, which is sought for in the instant petition by the petitioner, stood already modified by the Honorable Court in CO number 2501 of 2023. The instant petition does not indicate any further scope of revisiting the order of this court passed on 12/4/2023, which is already modified by the Honorable Court by order dated 12/10/2023 in CO number 2501 of 2023. Viewed thus, I feel that the instant petition being devoid of merit should be discouraged at once. My lord, so my lord, and the order dated 12/10/2023, my lord, we should go.
I've already placed
I've
that.
seen that order. I've seen that order.
My lord, I am subject to your lordship's permission, my lord. May I read, my lord?
Again, the entire order. Show me the relevant portion. I have read it once.
My lord, the entire fact is a factual dispute.
I have read it once. You don't need to repeat everything once because you are placing.
My lord,
You show me the relevant
factual
portion.
background, my lord.
Show me which portion you want to show in 12th of October
My lord,
2023 order.
by
which
the
portion?
first order, my lord, first page, at page 28.
Yes.
By
First
the
page
fir-
prayers
by-
have
by-
been
by
recorded.
the
I've seen
first-
that.
Not pressed, my lord. By the first
Arrangements.
order, the learned court made an interim arrangement for the petitioner to meet the son.
Yes.
He is 9 years old. The arrangement is as follows.
This stood modified by the other directions which were passed by the court. I have seen that. What else do you want to show from this order?
My lord,
Possibly my learned friend is saying that I messed up.
The honorable coordinate bench, my lord, entirely, my lord, dealt with the matter and the factual dispute and the factual background of the case, and has given him scope to visit the child and to assess the child on every weekend, and one night also has been given. So, my lord, in that case, my lord, I do not know.
Reverse that.
My lord,
if the same situation happens to you, will you be satisfied with your child?
My lord, my child is getting every access to the child.
Think of
my
the
lord,
child.
He is
The child
welcome,
also
my lord,
been
to come to the
deprived
residence
of the love of the child's father.
Lordship, I need to place a few judgments. So
my lord,
should I come back after the recess?
After recess, I have two fixed matters.
Because what my learned friend is possibly trying to say is,
opportunity, my lord, to controvert the.
Not at all required. I am not even looking at the pleadings made in the revisional application. Only the prayer and the documents annexed to it. All these documents
are false, my lord.
No.
The
That I
statements
say
are
that
false.
the
I have to controvert it.
Allegations are deemed to have been denied. When can you come back? Day after tomorrow or tomorrow?
tomorrow.
My lord, day after
Tomorrow you have
tomorrow.
a date.
Yes,
Day after
Lordship.
tomorrow.
Day after tomorrow.
Lordship. Same heading, Lordship.
Yes, yes. This revisional application.
dispose it off because they
have telling
are
me
also under pressure.
counterpart there before the estate officer is telling me that they are insisting on some order of from my lord. Very well.
I have because this is a matter of
নেবো এইটা অর্ডার একটা ছোট দিয়ে দিয়ে
Only
180.
May I pray for one indulgence, my lord? I'm mentioning out of turn, I'll just indicate what is the urgency. My lord, second May an order has been passed by which, my lord, interim custody has been granted to my husband. My lord, I stay with the minor children in Bangalore. My lord, there's a medical condition of the child, my lord. It's known to the to my husband as well as my in-laws. My lord, they have been asked to be handed over on the 9th. I'm only praying if it could be, my lord, I can file this, my lord, and serve them and come back to tomorrow itself, my lord. May I come back tomorrow, my lord? I'll serve and come. I'll file it, serve it, and come back tomorrow, my lord. There's extreme urgency because it's on 9th. Order was passed on 2nd, my lord. And my lord, the child is 15 years old. He was not even taken into consideration.
Tomorrow it won't be possible. Day after tomorrow.
Very well. Very well. So grateful.
File it, give the number.
We'll file it
and please serve them.
Yes, my lord, we'll serve and come back. Grateful.
देखिए एकটু দিন
555.
Mr. Dasgupta.
Yes,
I'm
ma'am.
passing it over. There is a 2 p.m. fixed
Yes,
matter. Till such time they'll pull out the file.
Yes.
I'll pass a short order so that both parties can pray for an adjournment till such time that I'm considering it. I'll not be able to consider it right now. Hearing it and passing order right now will not be possible. Today I'll be hearing another matter. But for today, you please adjourn it. Next day, I'll finish this.
আজকেই আছে ওখানে চাইছে that some order from court for adjournment, otherwise
leave to file. You have a certified copy, isn't it?
server copy.
Leave to file with server copy.
So this, my lord, I have made my submissions already, my lord. My learned friend, my lord, was to reply to that. Yes, my lord, that contempt, my lord, the order was very really, my lord, the main order.
May I, Your Lordship? May I? Few dates here, Lordship will kindly just note, Your Lordship, few dates. 20th August 2019. Is the order of CRP.
Just yes.
25th February 2020, order of liquidation. Now, between the order of liquidation and 3rd June of 2024, 10 e-auction notices for the sale of building, plant and machinery and vehicles were published by the liquidator.
Regarding notice on 3rd of June 2024.
10 numbers, different time. We did not get any bid, so were published. 11th e-auction notice was published on 4th June 2024.
11 June?
4th June 2024. No auction for the land. It is all the notices are for
4th June auction takes place.
No, the notice is there of 4th June
Fixing
2024.
3rd June, fixing 4th June as the auction date.
Yes, it is a notice for sale, 4th June 2024. On 20th June 2024, they file an application. Prior to that, no objection was raised at any point of time regarding this auction of this building, plant and machineries and everything. An order was passed on 3rd July 2024, violation of which they complained of. If your lordship takes that order, it is annexed to their supplementary affidavit, page 5. Of the supplementary affidavit.
Yes.
Now, your lordship will see the paragraph 2. Learned senior counsel submits the land for which the liquidator has issued the e-auction sale notice belongs to the applicant. Your lordship has that? Learned counsel appearing for the liquidator submits that the said land is not included in the e-auction. In this regard, learned counsel seeks to file an affidavit within a period of 1 week. And regarding lot 2, there is no restraint for e-auction as both sides confirm that the land in this lot does not belong to the applicant. Let the auction be held on the scheduled date, but the same shall not be finalized till the matter is heard out. So this was the order of the violation of which they are complaining of. Now, your lordship, no bid was received in respect of this 11th e-auction notice also. Subsequently, pursuant to an opinion taken from an advocate of this Honorable High Court, as well as the SCC meetings, there was an e-auction notice which was published on 3rd February 2025. That was 12th e-auction sale notice. Now, wherein the divisions were made, earlier the plant and machinery and building was together. Thereafter, in that e-auction notice, lot 1 was plant and machinery and vehicles, and lot 2 was the building structure at that property. Now, all such e-auction notices mentioned that these are the applications which are pending, and the sale would be dependent on the final outcome of those applications. So, e-auction sale notice mentioned about the pendency of the application as well as the sale would be subject to the outcome of those applications. Now, the only bid which was received was in respect of plant and machinery and vehicles. Thereafter, there was another notice which was published, 13th e-auction notice, which was published on 26th May 2025. So plant and machinery was sold pursuant to that e-auction notice of 12th e-auction notice. Sold in the sense the bid was received and the LOI was issued, but sales certificate was not issued because it was, though it was not on the plant and machinery, but whatsoever, we did not. 26th May 2025, 13th e-auction notice was published regarding this building structure. Pursuant to this, we received a bidder. Amount was paid by the bidder. Again, this was subject to the outcome that notice provided for. Now, after June 2025, I should kindly record in December 2025, they filed this contempt petition saying that there is a violation of the order of 3rd July 2024. Now, if your lordship kindly have a look at the impugned order, And it's at page 81. Page 81, volume 1. And then, Your Lordship, I'll just show Your Lordship. If Your Lordship will kindly take paragraph 3, where the prayers are. So Your Lordship will find at paragraph 3.2, 3.3.
Page 81.
Page 81 of the petition, Your Lordship.
Paragraph 3.2.
Yes, kindly see the prayers in the contempt is at paragraph 3. Your Lordship will find 3.2, wherein they say that the proceeded to issue further e-auction sale notices. Then Your Lordship will find that reliance on the opinion. Thereafter, they say that 3.4, in violations of the said order to publish new fresh e-auction notices dated 3rd February 2025 and 25th June 2025, Your Lordship finds 3.4. And the contempt is December. I'm just indicating. Now, Your Lordship will kindly take paragraph 5.1. Your Lordship will find on 3rd July 2024, having taken good note of the submission of the applicants that their land have been included in e-auction sale notice, this tribunal had restrained the liquidator from finalizing auction in regard to the said land. The said order reads as under, which I've already shown. Now, if Your Lordship will kindly come to paragraph 8.
Paragraph 8.
Paragraph 8, it's at page, क्या दिख रहा है? 91. मेरे इसमें पेज नंबर क्यों नहीं है? Paragraph 8, we have considered the submissions made by the applicant whose duty ends with bringing to our notice the alleged violation of our order. Your Lordship has that? We have considered the submissions made by the applicant whose duty ends with bringing to our notice the alleged violation of our order. We have already noted the tenor of the order passed on 3rd July 2024 and that it was passed in the context or rather being influenced by the submissions made by the applicants that the lands have been included in the auction notice and would be put up for sale. Now, if Your Lordship will kindly take paragraph 10, Your Lordship will find the e-auction sale notice dated 4th June 2024 does not find any mention of the land. Then kindly take paragraph 10.11. Thus, it leaves no room for any ambiguity or ambivalence in regard to the proposed action, which was towards sale of building and structures, plant and machinery and vehicle, as well as 8 trucks belonging to CD and not of any land. Therefore, the misleading statements made on 3rd July 2024 on behalf of the present applicants about inclusion of land had prompted this tribunal to restrain the liquidator from finalizing the auction sale. The applicants ought not to have misled their respective counsels. The applicants have, by unscrupulous ways, been successful to stall the entire liquidation process, preventing the liquidator from finalizing sale process by issuance of sale certificate in favor of the successful bidder. Now, if Your Lordship will find, there are 10.2 mentions about the e-auction notice of 3rd July 2024 and mentions that there was no mention of land and also that it mentions about the pending proceedings also. It is evident that the successful bidder is clearly notified that it would not acquire any right title over the properties until the sale certificate is issued, and sale certificate will not be issued pending operation of stay or any injunction. Here also we find no violation of our order. So Your Lordship will find even at 10.4, they say there is no violation of the order. Then if Your Lordship will find 10.5 also, that the highest bidder shall be declared, therefore no violation of our order. Then 10.6, the liquidator has clearly indicated the following in paragraph B, C, and 9. Kindly see paragraph 9, just the next page. Kya page number hai? Huh? 95. The finalization of the e-auction process shall be based on the outcome of the order of Honorable NCLT, Your Lordship finds. 10.7, thus it is evident that the sale shall stand completed only upon execution of certificate of sale, which has not been done as a successful bidder being represented by so and so, as the auction purchaser of HON'BLE fees has come up with an application seeking refund of the entire sale consideration and furnishing of bank guarantee instead, due to the fact that despite payment, the sale does not stand complete. Your Lordship finds that. And thereafter, Your Lordship will find Para 9 further indicates that the finalization of e-auction process shall be based on the outcome of the order to be passed by this tribunal in so and so. Here also we find no intentional, deliberate or contumacious violation of our order dated 3rd July. In the aforesaid backdrop, the application of contempt are dropped. Notices, if any issues are discharged, there should not be any impediment on the part of the liquidator to conclude the sale process with execution of sale certificate in favor of successful auction purchaser. So the contempt petitions are dismissed. Now, Your Lordship, the revision has been filed on the 2 bases that the contempt petition should have been allowed. That's one of the bases. Now, I will just indicate few paragraphs. If Your Lordship will just kindly once take paragraph 50 of the petition at page 39. Your Lordship kindly first takes paragraph 47 kindly. If Your Lordship also kindly takes once paragraph 45 at page 37. The petitioner states that this honorable court had been rightly approached as petitioner challenges the jurisdiction of the learned NCLT to pass the said impugned order, and the same is amenable before the honorable court under Article 227, read with Companies Act, Contempt of Court Acts, and the same is only revisable in the nature under Article 227. Your Lordship has that paragraph. Then if Your Lordship will kindly take paragraph 47. Your petitioner states that when the cause list was published for March 10, 2026, it transpired that the contempt petitions have been listed under heading pronouncement of orders, and the same day the other applications wherein the sale certificate is pending was already fixed for hearing at 3:30 p.m. A copy of the cause list is annexed. Therefore, the manner in which the order has been pronounced on the same date when the sale application are listed for hearing later in the afternoon, which demonstrate that the NCLT was proceeded in an unusual manner without giving adequate opportunity to the petitioner to test the legal veracity of the order impugned. However, after much persuasion and request, the learned NCLT has fixed the other applications wherein the issue of sale certificate was fixed on March 16. Your Lordship gets that date. However, even this short period which has been given to the petitioner is not sufficient for the petitioner to approach the appellate forum under the Companies Act 2013 in view of the lack of sufficient time to challenge the order dated March 10, 2026 because of the grave urgency, and has a regular appeal to be preferred before the NCLAT from the order impugned will take much longer time, which the petitioner does not have, because the applications for issuance of sale certificates will now be heard on March 16. And now in view of paragraph 12 of the order impugned, that the fate and outcome of those applications are known to the contesting litigant. Then kindly have a look at your petitioner says that the order impugned was uploaded in the portal in the evening of March 10. On the very next day, the learned advocate had applied for obtaining a certified copy. Then if Your Lordship will kindly see paragraph 50. There is a grave urgency in the matter. The urgency is such that the petitioner has no time even to go for an appeal before the Learned National Company Law Appellate Tribunal, as the bench is located at New Delhi, and time period from passing the said and fix of the said matter is 11:30 a.m. till 3:30 p.m. of the same date as the order impugned was uploaded in the portal. So in the evening, and the application for issuance is now fixed Monday, and therefore there is no sufficient time for the petitioner to approach the appellate forum. So the petitioner says that the purpose of reaching the unlearned unclad, the petitioner will have to file an appeal before the unclad, and for taking steps for completing the process, substantial time is being consumed. Your Lordship has that. So the ground which they give for coming to this court is that there is a grave urgency because it will take some time to file an appeal. So I indicate one thing to your Lordship, that NCLT and CLAT appeals are filed by way of e-filing and thereafter the hard copy. Even if the appeal is defective, one can mention before the chairperson court that I have a diary number, but I have an urgency in the matter, and we regularly do the matters there on that basis, and the matters are taken up if there is an urgency. So the contention of the petitioner is
even
that,
if they are defective.
Yes, the mentioning is allowed with the diary number. You mention the matter. You mention the matter, and once the court, the chairperson court normally passes that direction, and even the defective appeals at times even appear in the list also, with the appeal number, but it mentions that it is defective. It appears in the list. So the content, if we go and kindly have a look where I said that, I'll just show one or two more paragraphs, Your Lordship, just once. And paragraph 31 at page 24. The petitioner states that the learned NCLT, while passing the impugned order, had committed an error which is apparent on the face of the record by holding that there is no violation, and such error goes to the root of the matter. So, an appeal against an order wherein the court declines to pass an order as far as contempt is concerned. Going by their pleading itself, they say that an appeal lies in respect of that order, but as there, even you do not require a certified copy, even on the basis of the server copy also you can prefer an appeal. The ANCLAT, for the purpose of limitation, takes the date when the order is pronounced. That's the settled law. That's also been held by the Supreme Court up to the settled that the day when you pronounce that the order is pronounced, the limitation
starts.
So March 10 is the order. March 16th is the date when they say the matter is fixed before the NCLT. They come before your Lordship, 16th March ka order, and on 16th March, your Lordship has passed an order saying that you prefer for an adjournment in NCLT. So when they could come to the Honorable High Court under Article 227, they could have even filed an appeal there. I could have understood that you have filed, you didn't have the time, 2 days you had, you came 227, and in the meantime, you could have filed the appeal and said that very well, now I had this protection for few days, now I have preferred an appeal, so I can. This also has taken place at many a times, that you've gone before the appellate authority. So now they come before your Lordship under Article 227. For invoking Article 227 by saying that there is a grave urgency cannot be the ground for Article 227. Then, as far as the order declining the contempt, wherein the court held that there is no contempt, there can be no appeal against that order. An appeal lies against the order wherein the party is held to have committed contempt and punishment has been provided. Then you can prefer an appeal against that order, or I will just indicate, or there's a Supreme Court which says that in special circumstances where the contempt, there is an order which has declined to initiate proceedings for contempt. You can, in the special circumstances, what you can do is you may challenge that order under Article 136. This is what the law is. Now, the first part of this order is they're saying that the court erred, the tribunal erred in declining to initiate contempt. The second point which they take is, ground they take is, that while passing the order in a contempt petition, the court should not have made any comments on the merits of the matter. And specifically, they could not have said that there is no impediment in issuing the sales certificate. So the order is, in a way, not in so many words, but this order is without jurisdiction. So Article 227. Now, Your Lordship, on purely, I have already shown that on what ground they have come before Your Lordship. So as per them also, they had to prefer an appeal. The second part is, as I've mentioned, that as the court has declined to initiate contempt, that order is bad, so you interfere. So, Your Lordship, I'll show one judgment, Your Lordship. I'll deal with their judgment later on. I'm first showing one. Now, if Your Lordship takes this judgment of the Honorable Supreme Court, now here Your Lordship will find, I'll just first take Your Lordship to what the principle it has enumerated. Kindly have a look first at the principles which has been paragraph 13.
1.3.
1.3.
Yes.
The law on the subject is settled by a judgment of a two-judge bench of this court in Midnapur. Paragraph 11 of the decision sums up the principle succinctly as follows. The position emerging from these decisions in regard to appeal against orders in contempt proceeding may be summarized thus. An appeal under Section 19 is maintainable only against an order or decision of the High Court passed in exercise of its jurisdiction to punish for contempt, that is, an order imposing punishment for contempt. Second, neither an order declining to initiate proceedings for contempt, nor an order initiating proceedings for contempt, nor an order dropping the proceedings for contempt, nor an order acquitting or exonerating the contemner is appealable under Section 19. In special circumstances, they may be open to challenge under Article 136, which I just pointed out to Your Lordship. In a proceeding for contempt, the High Court can decide whether any contempt of court has been committed, and if so, what should be the punishment, and matters incidental thereto. In such a proceeding, it is not appropriate to adjudicate or decide any issue relating to the merits of the dispute between the parties. Number 4, any direction issued or decision made by the High Court on the merits of a dispute between the parties will not be an exercise of jurisdiction to punish for contempt, and therefore not appealable under Section 19. The only exception is where such direction or decision is incidental to or inextricably connected with the order punishing for contempt, in which event the appeal under Section 19 can also encompass the incidental or inextricably connected. Kindly see the last one. If the High Court, for whatsoever reason, decides an issue or makes any direction relating to the merits of the dispute between the parties in a contempt proceeding, the aggrieved person is not without remedy. Such an order is open to challenge in an intra-court appeal if the order was of a learned single judge and there is a provision for an intra-court appeal, or by seeking special leave to appeal under Article 136 of the Constitution. So if today, as per the contention of the petitioner, there is a direction in the order while dismissing the contempt, which on merits,
appeal was the remedy.
The appeal was the remedy, or you could have gone for Article 136. Revision court cannot be that they could not have invoked Article 227 and pray for this court to act as an appellate court in this respect. So, even assuming that as per them, then also, Your Lordship, they could not have it is a well settled also, Your Lordship, that the under Article 227, the court cannot exercise its power as an appellate court or substitute its own judgment in place of that of the subordinate court to correct any error. So the remedy was appeal. Even if we assume that there is an adjudication on merits, they knew that their remedy is appeal. They could have gone to the appeal court, because after the 16th March date, the matter was thereafter posted in April. The matter was thereafter posted in April. Now the matter is posted on the 7th of May. So in view of this, now I'll also indicate one more thing here. If Your Lordship will kindly see paragraph 18 of that judgment, that Ajay Bhalla judgment, which I was showing. Yes. Here, Your Lordship, there was an order of the contempt. Thereafter, letters patent appeal was preferred. The division bench declined to pass any order as such. Against that, there was a Supreme Court. If Your Lordship will kindly see paragraph 18, just before, firstly, two aspects were covered by the judgment of the single judge. Firstly, a finding that the appellants were guilty of contempt of the order dated so and so, and secondly, but no punishment was provided. And secondly, that the respondent was entitled to promotion of the rank of IG. The first aspect is not amenable to an appeal under section 19. The finding that the respondent was entitled to promotion to the rank of IG would be amenable to an appeal in terms of the law laid down by this court in Midnapur, more particularly in paragraph 11V, which has been extracted. Now, Your Lordship, my learned friend had relied on the division bench of order of this Honorable High Court, order. अरे what do you mean by इनके पास होगा, हम अपने लिए मांगे. ठीक है, तुम इसमें खोल के दिखा. Your Lordship takes that judgment which was relied by them on Brahmadeva Mishra versus State of West Bengal. They had relied on. Now kindly have a look at the facts of that case once. Your Lordship has a copy of it, or I should have had it? Your Lordship has this. if your lordship will find, this is an application in an appeal filed against an order passed by the learned trial judge. By consent of the parties, we have taken up both the application and the appeal. The impugned order was passed in relation to an application for recalling of an earlier order dated 19 September. The operative portion of the order dated 19 September is quoted below. Considering the submissions recorded as above and the materials placed, this court directs the DI to take steps for approving the petitioner against the vacant Group D post lying in the school in issue within a period of 4 weeks from the date of communication. The petitioner shall be entitled to all regular and arrear benefits admissible in law in terms of the approval so granted by the DI. For the above reasons, the conclusion arrived at by the DI pertaining to the non-approval of the petitioner as a Group D staff stands set aside. The impugned order also dealt with a contempt petition that was filed in relation to the order dated 19 September. The learned trial judge took both the applications of recalling and contempt analogously and modified his earlier order in the following manner. An excerpt of this order is reproduced as under. Now, if your lordship kindly takes paragraph 5. So the court modifies its earlier order by recalling. Counsel on behalf of the appellant submits that the impugned order is against the principally established law, as the learned trial judge proceeded to recall his earlier order and pass fresh orders in spite of the fact that the learned judge did not have determination to hear the writ petition. The learned counsel further submitted that the trial judge had no power to modify his own order in sitting in contempt jurisdiction, and accordingly the order is illegal and needs to be set aside. Mr. Mukuso and so submits that the trial judge was correct in passing the above order, as upon hearing the entire matter once again, he chose to recall his earlier order. According to him, this power is very much deal with the trial judge and he can recall his own order. He further submitted that there is no bar in the contempt jurisdiction that the learned trial judge cannot pass directions. We have gone through the materials records and heard counsel. We are of the view that the learned trial judge should have dealt with in a segregated manner. In the event he chose to hear the recalling application first, he should have the jurisdiction to recall the same. However, since he did not have determination to hear the matters in relation to education when these orders were recalled, he could not have issued fresh directions upon the respondents. And on these facts, the reliance is made on paragraph 9 on the judgment of Union of India versus Subedar Devasi, and the order was set aside. So, and one more thing. Petitioners before your lordships are all the related parties of the corporate debtor, all controlled by the suspended board. All of them, all the parties. And this is an admitted fact. All the companies who have filed an application for revision, they are all the related parties of the corporate debtor. It is the suspended board who controls all these companies. And in fact, all the person is behind the bars, Mr. Harish Bagla, under the PMLA proceedings, the person who is in control of all these companies. So the Honorable Tribunal, while taking into consideration all the facts that they're trying to stall the liquidation process, what they do is they file one after the other applications and they do not let the liquidation proceedings move in whatsoever manner. Now, coming on the law point, my answer to this is that even if you are aggrieved by an order, the forum is not that you can invoke Article 227. There is a remedy which has been provided in the cases where even there is any directions or is there anything on the merits also, you can prefer an appeal, because it is not this, after the NCLT, you can prefer appeal to NCLAT. From NCLAT, there is an appeal to the Honorable Supreme Court. So it says either you apply under 136, and if there is an intra-court appeal, it's permissible. So in view of the above, this petition, your lordship, needs to be, ought to be dismissed, your lordship. And you can these are my submissions.
Yes, Mr. Bench.
Lord, the question is not, my lord, whether I have to prefer an appeal. The question is, my lord, whether a revision under 227 is maintainable or not. Under Article 227, my lord, is maintainable or not. That, my lord, the criteria which, my lord, we relied upon.
It is maintainable, whether it is entertainable or not.
Yes, whether it's entertainable or not. My lord,
Because it's always maintainable since there can be no law.
it's a constitutional, correct. I
Applicable.
absolutely. My lord,
226 to 27 is always maintainable. Whether
it's entertainable or not. Correct.
In the facts of the case, if there is an appellate remedy available,
yes,
then in that case, what was earlier self-imposed restraint is now sort of judicial discipline, not to entertain.
my lord, we relied on a judgment, my lord, which order of, my lord, where, my lord, has entertained a 227 from an order of the NCLT by saying, my lord, that order was without jurisdiction. And that's, my lord, I understand, my lord, that's one of the criteria, really,
Yes.
for it to entertain. Because, my lord, there's no point in saying that I should go to Delhi, file an appeal under the NCLT when, my lord, I have a remedy perfectly available to me if the order is, because it's not against all orders that, my lord, I can come here. If, my lord, if we are correct in showing that the order is without jurisdiction, then, my lord, in my humble submission, there's no reason why, my lord, from Kolkata NCLT, my lord, the Calcutta High Court will not, my lord, entertain a civil revision petition. We have relied on, in fact, two, my lord.
Judgment
The actor, this is, my lord,
you had shown only one.
EDCL Infrastructure Limited.
You had cited, I think, Atin Arora.
I think, Your Lordship, only one judgment was given
No,
to us.
EDCL Infrastructure.
No, আমাদেরকে তো শুধু
No,
একটা
Justice Rice judgment নেই?
No, the day we appeared, only this was the only judgment which was shown. So I do not know.
You cited Atin Arora.
Not on the day when the matter was argued.
This is the only one which I.
Then maybe on the first day when they moved.
First day it was cited, my lord, it's, my lord,
No, then I am not aware of that.
2020 SCC online Cal
Take a copy,
2656.
Just give a copy. But otherwise, I would have. Because on the last occasion when they moved, the petition was heard, this was the only judgment.
Yes.
For the Mishra only was cited.
এইটা তোমায় পেয়েছো
কোনটা?
Atin Arora.
No, this one was cited.
It
on
was
the-
cited, but it was cited on the first day.
It was cited on the first day when we were not there, so I'm not aware of this.
Oh. My lord, these two judgments, I thought, my lord, we had shown, my lord, this is also.
So the order was completely without jurisdiction. Otherwise.
Yes.
My lord, at paragraph, Atin Arora, my lord, paragraph 34. Onwards, my lord, where the power of, my lord, the and, my lord, both Atin Arora and my lord's order, both are, my lord, from orders of, my lord, the National Company Law Tribunal.
PL is an interim order.
Yes.
So it's not yet a precedent.
Sorry, my lord. Yes, it is, my lord, an interim order. Correct.
Not-
Absolutely.
It is not
Absolutely.
yet a precedent. So
Absolutely. My lord, so far as, my lord, Atin Arora is concerned, that is, my lord, from a.
NCLT order.
না দুটো এনসিএলটি একটা
দুটো
হচ্ছে অন্যটা ইন্ট্রিম অর্ডার বলে তাই এটা
First paragraph is.
না এই জজ সাহেবের এটাই
হ্যাঁ, এটা তো
the revision lab the first one which Malad
it is an
entered
interim order. So
yes
it
yes
should be-
but Malad had entered Malad what I'm on
effect.
yes
Even
Malad I'm
on me.
sorry Malad
It doesn't have a binding effect even on me. I can still dismiss it.
yes of course
After hearing the
Of course.
sites, I can still say that.
yes yes Malad can
So
Malad can.
therefore,
it may not have a binding precedent but Malad Atin Arora Malad is one of them now Malad and Malad the division bench Malad which we had cited that is Malad at paragraph 10 এটা তুমি যেটা দেখালে হরিশ this is Harish sir.
Yes, that was cited.
Malad, because the question involved is whether, Malad, in dealing with a contempt petition, the NCLT could have passed two directions. One direction is to dilute the previous interim order which was subsisting, and in effect vacated the interim order. Because in the contempt proceedings, it said that no, you go ahead and have the issue the sale certificate. So what is the meaning of that order, Malad, which was passed and was subsisting? Today, Malad, we are only on that question. Malad is looking at Malad whether Malad the NCLT today has committed Malad a jurisdictional error. Now the jurisdictional error is whether in contempt proceedings you can pass an order which will affect the merits of the matter, or will vacate the interim order which has been passed, against which you have gone up in contempt. That's one of the proposition which we are looking at. Malad recalls Malad those directions Malad in paragraph 12 and 13. Because today Malad the admitted position is what? Malad, I am a incorporated company who come and say that look, the land on which all these machineries are situated are mine, which is an admitted position, and which is not of the corporate debtor which is undergoing corporate insolvency resolution process, including liquidation sale. I am saying when you sell the machineries which is embedded on the earth, then what happens to my land?
That is
that's on merits. That's what Malad the main application is. That's why Malad in the application Malad
not have gone that far to say that this will not affect the sale now. You can go ahead and proceed with the sale.
Yes. So that is on merits, and that is my application. On that basis, you passed an interim order. After considering Malad the application, you passed an interim order.
But in the revisional application, you don't say that since the order is there without jurisdiction, therefore this civil revisional application under 227 should be entertained. You rather say that since there is such pressing urgency that you cannot approach the NCLAT, that this 227 application should be entertained.
Malad, in the civil litigation, Malad, both are Malad. It is
because the pleadings are that because of the urgency involved.
No, that's why Malad we approached immediately. Malad, ground 38. Page 30. Page 35.
Page 35 ground.
It is there. It is there.
Malad, it will be there, Malad. That's Malad also one of the grounds. Urgency, Malad, we showed Malad to get an interim order, Malad, from the Honorable Court. Page. It is there, Malad. $38, Malad, ground 38. Page Malad 35.
No, but this, Mr. Banerjee, this is in continuation of what you have submitted earlier in the earlier paragraphs, which says that NCLT has committed a mistake in not coming to the conclusion that there was a violation. Or
Yes, but Malad, this is independent of that. Urged by acting in excess of jurisdiction to pass a direction as contained in paragraph 12 of the order impugned dated March 10, 2026. And look, kindly look at Malad the direction.
Where did you read?
Malad, sorry, Malad, page 38, Malad, I read. Page 35, I read. Ground 38.
Ground 30.
Ground 38. I'm sorry, Malad.
I was reading para 30.
I'm sorry, Malad.
Also, ground 30 and 31.
Yes.
Yes. 30.
30, 31, Malad, and
Yes, Ms. Mutoria, if this is the case that there is an excess of jurisdiction, then in that case, civil revisional application can be entertained. If there is an excess or lack.
I'll just indicate. Now, Your Lordship, when Your Lordship sees that Ajay Bhalla order, it is specifically on if there is a contempt proceeding and if there is.
That is in the context of whether a challenge can be thrown.
Correct.
Now, the forum of challenge,
Yes.
if it is there
Yes.
by way of an alternative remedy,
Yes.
why should the petitioner not have that liberty?
So the
if
fourth-
the
so that
case
is
falls
what-
within one of those pigeonholes.
No, this is exactly, Your Lordship,
Now,
why
this Ajay
if-
Bhalla
if Your
was
Lordship
not
sees the
considering
point
a
five-
case. Yes, it was not considering a case of alternative remedy there.
No.
It was considering the case of lack of an appellate remedy. If there is a lack of appellate remedy, then 136, because against an order passed by the High Court, there could not have been a 227 forum available.
Now, if
In
Your
this
Lordship-
case, if a 227 forum is available, then
Now, Your Lordship, may I just indicate one thing? It is their own case. That's why, Your Lordship, I showed, if Your Lordship sees paragraph 50, and Your Lordship will kindly come back to paragraph 50.
yes, paragraph 50, they have
So
pleaded
they
urgency.
say that we do not have the time to go for
No,
appeal.
but they also say this in ground 30,
Yes.
that NCLT has gone into the merits of the order, which is patently part heard and yet to be disposed of. And then see ground 31.
Yes.
38.
Yes. But if Your Lordship sees paragraph, so these facts have been stated prior, whatever the jurisdiction, if they have said that they could not have commented on the merits of the matter.
So that is an additional pleading.
Yes.
That
So
it
now-
is an error of jurisdiction and there is urgency also.
Yes. So now the question is, why do they say that? Why do they have? They say there is a grave urgency in the matter. So that's why they're not
Right.
going to the appeal.
Let us cut this down. That yes,
Very
this urgency part goes.
Very well.
If that goes, then whether it is entertainable or not. Now, if we look at it from this perspective, then
Yes.
can we entertain this writ petition, this revision?
Your Lordship, my humble submission would be that in view of the judgment of the Honorable Supreme Court, which says that as far as the contempt is concerned, if the court declines to initiate proceedings for contempt, that order is not appealable. And if in the case, if there is any comment on the merits or if there is any directions as far as the merits is concerned, then the party has a remedy. And that remedy is that you can prefer the intra-court appeal or you can go for the Article 136. Now, on the merits, even if this is in relation to the case which I have relied on is on the contempt. It is on the contempt and the contempt proceedings. There were directions which were passed by the court in the contempt proceeding
And on the
itself.
merits, what is your submission? Is it an order which could have been passed by the NCLT in exercise of its contempt jurisdiction? Do you say that it is not in excess of jurisdiction?
If Your Lordship
it was
sees-
within its jurisdiction?
Your Lordship, my humble submission would be that it is not in excess of the jurisdiction. Why this NCLT? If Your Lordship sees even the order of the NCLT, Your Lordship, that's why I took Your Lordships to all the dates and the relevant, that the land was never the part of the e-auction process. It was the building and the plant and machinery. So now the court also says that this order was passed on the basis that there is an auction of the land, but it is found that there is no auction as far as the land is concerned. And then the court says that we do not find there is any violation of any order. So there is no impediment in the issuing the sales certificate. So this is what the court says. Court says nothing more, nothing less. And 3rd July 2024 was also an interim order. It was not a final order. The 3rd July says that do not, the order language was the final. The sale should not be finalized.
Then is this order not going to influence the applications that?
Now I'll just indicate this. What is their application? Their application is that the land belongs to me. The liquidator is also not saying that the land is in the name of the corporate debtor. The liquidator is saying what I'm selling is the building and the plant and machinery.
Which is situated on land.
Even if it, and not only this, then may I just indicate Even the
But
PMLA.
that will then be decided in the application.
Yes,
See,
yes,
now-
I am saying so, but you can't vacate the interim order and say issue sale certificate.
Now I'll indicate, your lordship. Even now they are saying this land belongs to them. It is. There is a PMLA proceeding wherein the PMLA says that all these lands have been brought from the money of the corporate debtor and the other Amrit Group companies. So there is a question mark as far as their contention is also concerned. And secondly, after this, this order was passed on 10th of March. On 12th of March, we have issued certificate of sale. We have given possession to the auction purchaser who has come in on 12th of March. And on 16th of March, there was an order from your lordship, which we received, that your lordship had said for the adjournment to be taken there. Now the matter is fixed there on 7th of May. The matter is fixed on 7th of May. So whatever they want to say, they can say there. They can say there. It is not, that's what I'm saying. They are not remediless. They are not remediless. They themselves say that there is a grave urgency. That's why I am not going to the NCLAT. I have come to this court. That is what they are. Now if they say that your lordship has the jurisdiction because it is without, the order is without jurisdiction, then where was the question of that I will go away because there is a grave urgency, otherwise I would have gone to the NCLAT? Then those paragraphs would not have found place at all. Then what would have found place is this order is without jurisdiction. So I am invoking Article 227. That is not their case. What they say is that there is a grave urgency, and if I go to the NCLAT, there is a very less time, and because the NCLAT is in Delhi and the matter is fixed on 16th, that's why I'm coming here. So in these facts and circumstances, your lordship, my humble submission is that your lordship would kindly ought to dismiss this petition.
Well, may I just conclude, my lord, since my lord asked. My lord, in my lord's, my learned friend's judgment, which Supreme Court, which was relied upon, my lord is absolutely correct. My lord looks at 13.4 and 13.5. Supreme Court says, my lord, exactly, my lord, what we are also, my lord, advocating here.
We are relying on that only. That even
Any direction, 13.4, my lord, page 5. Any direction issued or decision made by the High Court on the merits of a dispute between the parties will not be in the exercise of jurisdiction to punish for contempt, and therefore not appealable under Section 19 of the Contempt of Courts Act. Section 19 anyway, my lord, deals with High Court appeal, my lord, under High Court, my lord, when it's passed, my lord, by a single judge. The only exception where says direction or decision incidental. Then, my lord, 5, very important, which my lord pointed out. If the High Court, for whatever reason, decides an issue or makes any direction relating to the merits of the dispute between the parties in a contempt proceeding, the aggrieved person is not without remedy. Such an order is open to challenge in intra-court appeal if the order was of a learned single judge, and there is a provision for an intra-court appeal, or by seeking special leave to appeal under Article 136 of the Constitution in the other cases, which means, my lord, there is no direct appeal. Today, my lord, in the revision, I have, my lord, come with a case, paragraph ground 38, specifically ground 30, 31 and 38, saying that, my lord, that order is without jurisdiction. There is, my lord, an order which was passed saying, my lord, and I am quoting, my lord, from the order, let the auction be held on the scheduled bed, but the same shall not be finalized till the matter is heard out. My lord, matter is still pending. This is, my lord, the original. It is quoted, my lord, the order of, my lord, it's, my lord, 3rd July is quoted. It's also there in the supplementary affidavit, and in the impugned order, my lord, this order is, my lord, quoted. And then, my lord, paragraph 12, it is said, my lord, by the NCLT that there should not be any impediment on the part of the liquidator to conclude the sale process with execution of sale certificate in favor of successful resolution applicant.
Sale certificates have been issued.
Yes, the possession has been given, the sale certificate.
That's the end of my application. You dispose of my application, you give a direction there, you dispose of my application. Well, kindly see, my lord, what is the exercise of jurisdiction here? Well, lord, we are only on the proposition of law. We are on the proposition of law as to, my lord, in a contempt jurisdiction, whether, my lord, an order passed in another application can be, my lord, set aside.
Pending only on the faith that will come back.
Because that is the application which we have filed as an order. Well, this could be of other courts also. And you said that that's one of the proposition of law. And that's what we are agreed by. And when we come before a court, urgency is already always can be there. Just because I say it's urgent, that doesn't mean my jurisdictional issue goes away. Urgency is only to have the matter heard. Urgency is only for the matter to be heard. Otherwise, why should the court entertain when it's not urgent at all?
Pending here, they had the notice that the matter is pending.
We are on the question, we are saying that the order is without jurisdiction. And additionally, we have also said, please take it up because there is urgency. Because the matter was fixed on the next date. That is why, and possession so far as we don't know what my learned friend can clarify. After we have filed the matter
Served on them.
and served on them, then they have given.
No, no, that's not correct.
Position.
No.
We are not aware.
No, that's not correct.
We are not aware.
No, we have not.
Because we filed, has seen when we are. But I'm not going into it. We are on the question of entertaining and whether this order can be sustained or not. This order can be sustained or not. We are only on the jurisdictional issue. Well, the order impugned is in excess of jurisdiction past, which vacates an earlier order when that was not being exercised. I'm grateful.
Your Lordship, only apropos what my learned friend said about the High Court, Section 425, Your Lordship will kindly note of the Companies Act, which says the tribunal and the appellate tribunal shall have the same jurisdiction, powers, and authority in respect of contempt of themselves as the High Court has and may exercise for this purpose the power under the provisions of the Contempt of Court Act. That's why I said appeal, intercourt appeal, and
No,
then
I am aware of it. That's how contempt jurisdiction is
even
exercised.
50 also, the paragraph, they said that it was only for the purpose of urgency. Then kindly see, there is a grave urgency in the matter. The urgency is such that the petitioner has no time even if to go for an appeal before the Learned National Company Law Tribunal.
Anyway, now there's no question
This
of
is-
appeal.
I have, these are my humble submissions.
এখন তো আর appeal এর প্রশ্ন নেই, 10th March তে।
Your Lordship, only I have to submit, the matter is fixed
April,
before the NCLT on 7th of.
That we'll await the decision of.
No, there are other applications also.
No,
As far
only
as
this
is
application. Of
concerned,
course, only
no?
this, so far as this is concerned. No, only so far as this is concerned. I'm sure we'll all give that kind of
Mr. Banerjee,
respect.
He doesn't appear before the NCLT in this matter. That's why I'm just indicating. He
Correct.
appears.
We will, so far as this matter is concerned, we will take time till this matter is decided.
Your Lordship wants any written notes?
I'll be fixing it on Monday.
Monday.
Very well.
If I'll go through the file, if I have something, either I'll
Very well.
close it on that day. Or
Very well.
Very well.
Any time, Your Lordship?
Yes.
Obviously, we'll look.
Same.
Monday तारीख क्या? मेरा diary है। Where is my diary?
সোমবার কিছু আছে দিদি? থাকলেও তো বেশিক্ষণ লাগবে না।
Is my purse? Where's my purse?
Third, Miss Victoria, learned advocate appearing for learned senior advocate appearing for the for the opposite party, and Mr. Banerjee, learned advocate, learned senior advocate appearing for the petitioner. Full stop. List this matter for further consideration on Monday. Monday?
13. Oh, sorry, Wednesday, 11th.
11th. 11th.
No, Monday is 11th.
11th.
2 p.m.
Very well.
And 7th, this matter we are taking adjournment.
Which one?
This matter, so far as this.
Let it be recorded now.
On 7th. What is the recording? On 7th, we will,
7th.
as far as the applications concerned with this is concerned, we will not
Yes,
have
quite
anything.
naturally.
But there are other applications in relation to another properties. Of
No,
course,
that is different. That we are not. Keep.
কি ভাই উত্তরটা মানে কি আছে? Don't have all
Everything cannot be recorded.
Yes.
Absolutely.
Not proper.
the matters fixed.
আরে ওখানে বলে দিও না, তো আছে।
ঠিক আছে, 3:30.
I'm grateful.
Thank you.
I'm grateful.
আরে কেন দরকার জজ সাহেবকে ডিসাইড কিচ্ছু লেখে
এদিকটা এই দাঁড়িয়ে ছিল তো গল্প হাতে 7 কুইন্টাল এটা এদিকটা এদিক
I'm opposite. Oh. Okay. But he's just standing outside. He doesn't know. I've sent. Then again, this. Last. No, this was the today's Milord, how they have fixed it, Milord, as last chance. That we have placed our adjournment petition, but they are seeking some order from my lord so that they do not have to answer to anybody. Well, it's there what has been told to my counterpart.
He's on his way. He's coming.
এক্ষুনি দাঁড়িয়ে ছিল তো
No, I message.
আচ্ছা
What was your case, Mr. Chatterjee?
My lord, my case was, my lord, here what happened, my lord, I filed a suit, my lord, saying, my lord, I have a right as a lessee in the property. Now, my lord, there, my lord, I prayed for an injunction, my lord, not to disturb my possession without due process of law. This was my prayer of the injunction. My lord, court has said that it is not eager to pass the injunction, my lord, on the ground, despite holding, that I take to the lordship impugned order, that I have an arguable case made out. That I have an arguable case to the extent that, yes, I am a lessee, because there are government orders coming in where it says that the lease, those have expired, will continue till a policy decision on the issue in the Barakpur cantonment area. So that 90 years which have expired, that will continue for every year. This continuance has continued every year by individual notifications. Now, my lord, I have placed that notification on that date, my lord, saying that till it is continuing till 2027. Now, my lord, considering that court says, yes, there is an arguable case, but my lord, court has refused to pass an injunction order. Now, my lord, what happened, my lord, in the meantime, my lord, during when my lord was also hearing, my lord, the authorities have initiated a proceeding under the Public Premises Unauthorized Occupants Act. Now, my lord, there, my lord, we pray for time, saying that my lord is in session of the issue. Now, my lord, a question cropped up, my lord, while I was arguing, my lord, that now in the changed circumstances, whether my lord would change the relief to the extent of laying its hand off till my lord decides the issue, or till the issue before the suit court is decided, because it is intertangling. I am saying, my lord, I am a lessee because of a government order. The authorities are issuing under the Act 1971, you are an unauthorized occupant. So, my lord, where, my lord, they can decide whether I am an authorized occupant or not, but they cannot decide, my lord, declare, my lord, me to be lessee. So, my lord, the issues are intertwined. My lord, same issues, same argument will be advanced in two proceedings. Parallel proceedings are now going on. Therefore, my lord, since my suit is continuing till date, and where before them I cannot have a counter claim.
Can a suit continue in view of express provisions of the
Yes.
public premises
Yes,
eviction of unauthorized?
because under the Act 1971, my lord, I cannot have a relief seeking my declaration, because there is a transfer has occurred. My lord, I am declaring myself to be a lessee because they have allowed my transfer till 2017 to 2022, and after that the lease has expired. Now thereafter the government notifications comes in. So, my lord, my declaration I cannot pray under that act. So, therefore, if that declaration cannot be there, which is within the scope of, my lord, the suit, my lord, I cannot have a counter claim in 1971 Act. I can defend myself, but can I have a counter claim, declaratory relief before the authority under 1971 Act? Well, in my respect, Section 5 is not within that scope, or Section 4. So, my lord, if that be so today, my lord, so if suit courts, my lord, this will anarchical situation. My lord, I proceed in suit, I get a relief. Now they proceed, declare me another. So each is affecting each other. So in that circumstances, my lord, either, my lord, in my respectful humble submission, they have to lay their hands off. Suit can be expedited, can be decided within a year.
That can't be. Then in that case, the very object of the public premises eviction of.
My lord, I have a decision.
Will show me that decision.
Yes. My lord, firstly, my lord, specific relief act here. Decision. Specific relief act, my lord, sees, my lord, there is 41A probably, my lord, where the relief I can seek an injunction in a judicial proceeding. Now, my lord, this এটা কোনটা? পাবলিক suitor of injunction. এটা কোনটা? যে একটা কপি দে জজের কপি। Kindly have. So this is in Indian law reports, ILR or AIN 1931 Calcutta, my lord, equivalent citation 279. Lord, kindly turns to me, lord, page 1284. এটা equivalent citation দিচ্ছি AIN 1931 Calcutta 279. My lord, my lord has got page 1284, my lord. My lord, I am reading from I agree. I agree with the opinion expressed by Justice Sale in such and such. The spirit of cooperation existing between the courts in India will often be sufficient alone to make such orders effectual, where otherwise they might not be apart altogether from reciprocatory rules, such as those relating to the transfer of degrees for execution. I have little doubt that the learned judge at Agra will assist in making the order of this court effectual when it is brought to his notice. Even if this were
public premises eviction of unauthorized occupants.
my lord, today, my lord, I am handicapped. My lord, I can not have একটা বই দাও।
Judge,
my lord.
You can certainly have this as a defense before the public premises author, I mean the estate officer.
Yes, my lord, I am never saying, my lord, I can defend. My lord, my scope of the suit is different.
That it should be stayed is.
My lord, it should lay off its hand.
Because of the suit being pending there, suit will continue and the proceedings will never be continued. Every tenant will have that right then.
My lord, today
Not
kindly
because you
visualize
are
the
there.
situation. Kindly visualize. My lord, if I am within the scope, my lord, I have nothing to say. My lord, it is what they are saying. My lord, what is their impugned notice and what they are saying. My lord, today they are saying that I am not a lessee because your lease has expired. This is their base.
Yes.
Now, my lord, I have produced notifications saying government is extending my lease year to year because they are awaiting formulation of a policy.
Yes, Mr. Dasgupta, what is your
my lord,
answer to this?
that is not automatic, my lord. I have given up another notification. They have to make an application online and then it has to be done. And even if it is not done.
Which is the date of the notification?
My lord, 12.
Oh, no. 2026 notification.
2017 notification.
I have given you a copy. Yes, I have seen.
2017.
My lord. Kindly see. This is procedure, my lord. Second page, my lord.
First policy decision to আছে এখানে।
This is the procedure B 2017. 10th March 2017.
So kindly see. My lord has that 2026 which I have handed over.
I have this 2022 thing. I don't have any 2017.
2017 is, my lord, part of my application as well.
Part of your revisional application?
Yes, my lord. Revisional application.
Page?
20. My lord, that is at page 105, 2017 if they rely upon.
Page 105.
Yes.
Yes.
Copy a text. This is a much clear copy.
Yes, that is more legible copy. My lord can have it.
Yes, what is there in this 2017 thing?
কি দেখাচ্ছে 27?
Well, 2017 আমাকে একটা কপি দাও।
এখান থেকে না।
Well, there is a process to a procedure, my lord. There is a process to apply. Second page, my lord.
B, yes.
There is a process, my lord.
So according to you, he has not applied through this procedure.
My lord, he has not even applied. Even my lord. Kindly consider a case where he has made an application and it is kept pending. My lord, by a suit, can it be enforced, my lord? If it cannot be enforced, my lord.
And Mr. Chatterjee, what is
extension
your,
of lead,
you
end
have
of the day.
applied?
Yes,
According
Milord,
to you,
because
you have applied.
because I have applied, Milord, before the authorities saying my lease has expired, extended, and they have issued then the impugned notice saying it has expired, please leave. Now, Milord, after that, Milord, 2017 was prevalent, my lease expired after 2017. So at that point of time, Milord, 2017 was not affecting me. So, Milord, it expired, Milord, my lease expired on 2025. July 2025, right? July. Yes, 19 July 2025. So, Milord, after 19 July, this 26 which has come in, it says, I am directed to convey that the applicability of interim policy issued by such and such 2017 as amended from time to time is extended beyond 31st of December 2025 for 1 year or till finalization of comprehensive lease policy, whichever is earlier, to deal with the issue of extension and renewal of expired or expiring lease of defense land.
Yes. So
Milord, this
2017 is been
extension and
extended.
renewal, the entire policy is, Milord,
Somewhere it has to say it will be automatically registered without anything, doing anything. Somewhere in either in 2017 or in 2022, it has to say that an lease which has expired will
No,
automatically.
but if he says that his lease was supposed to expire sometime in July 2025, and before expiring he has applied, then
Yes,
in that
he
case,
has.
now during pendency of his application for renewal or extension of lease,
Right.
whatever may be the name,
Right.
if this notification comes from the
No,
government of India,
2022 comes every year. It is extension of the 2017 policy, my lord. 2017 policy was a limited policy. So it is extended. Every year it is extended. That is not disputed.
so that application which he makes,
My lord.
that
Remains
application is
pending.
subject to approval.
Yes,
Subject
pending.
to approval. It has to, my lord, a lease.
Show me that procedure in 2017 notification.
Rather, Milord, 2017 supports my case, saying that you cannot take away lands which are in civil area. That is what 2017 is, and trial court has also gone into that, saying you have an arguable case.
No, 2017 I was reading procedure, my lord.
You have obtained an order from the trial court.
No, trial court says you have an arguable case, but I am refusing to grant. Kindly text the impugned order, my lord.
So against this, you are up in revision.
Yes, I went before the appeal.
His case is that he wants an interim order where a lease has not been extended.
No, I
could have understood. I could have understood had he moved a writ petition and sought a mandamus upon the executive to do something. Here, my lord, he has filed a suit. But a suit cannot extend. Suit court cannot extend a lease unless he shows that it has already been extended.
But it is extended.
There
It says
cannot-
it will extend. It will
No,
continue.
Policy is extended. His lease is not extended. These
Right,
are two different things.
He is right in submitting that. It is not the lease. It is not your lease that is being extended.
It is the policy which
because if the lease itself had been extended, then in that case, this provision, I have also read it.
Yes.
This provision which you
Yes.
just now showed,
Yes.
this would have been rendered meaningless. If you see, I am
Yes.
directed to convey as from time to time is extended for 1 year till the finalization of the comprehensive lease policy. It is for the policy.
Yes.
Whichever is earlier to
Yes.
deal with the issue of extension. So
Yes.
the issues of extension and renewal of expired or expiring leases is to be dealt with in terms of a policy which expired on a particular date and which policy has been extended. That is the
Yes.
meaning. It's not the lease itself which is
Milord,
being
kindly sees, Milord, if 2017 is being continued every year, part A, BA is important. All leases given under the cantonment code and
where is that?
Milord,
Which
the
page?
2017
Yes.
first page, Milord. One
Page BA, yes.
Yes. All leases given under the cantonment codes and 19 whose full term has either expired or is expiring before such and such will be extended. So it is being extended.
Subject to the following conditions.
This is the
Subject to the following conditions given in succeeding paragraphs. Milord, kindly sees. So there has to be an eviction order, then it will not happen. I'm not governed by, Milord, one extension in such cases will not where transfer or sublease assignment were made after the expiry of full term. My transfer has happened before expiry. I am not governed by that. Lease shall not be recovered, Milord. This is not their case when extension, then 4, Milord, extension lease up to will not be regularized. Breach of lease, there is no breach of lease condition. So, Milord, I am not falling into these conditions. It is not their case even. Their only case is it has expired now. Please leave. Now that too, my lord, when my lord is hearing on the injunction where my lord, I was saying please protect my property, protect my possession. Now my lord, in the interact while deciding, my lord, deciding the issue, my lord, they initiate this proceeding.
Now, my lord,
Now, my lord, in this change circumstances, my lord, I was arguing with
এখানেও তো বলা আছে অ্যাপ্লিকেশন এইটা এই যে
তারপরে আরে
Yes, Mr. Dasgupta.
Well, what I am saying is, this is the procedure for extension. It,
Mr. Dasgupta, this policy of 2017 has been extended from time to
yes,
time.
I have noticed.
And that policy is still in force.
Yes,
Now, if you take that policy, BA, the paragraph which you are showing at page, at the first page of the 2017 policy, it says that in cases where either eviction orders have been passed or any litigation is ongoing regarding the leasehold rights. In such cases, leases will not be extended. Then, where there is any transfer, sublease or assignment of leasehold rights after the expiry, and then it is about lease rent, fixation. He does not fall within any of these clauses.
No, three is important. This is one step which the authority has to do if it intends to extend the lease. This part, 3. First, this rent has to be fixed.
It is up to you. You ask for that rent.
Yes, we are ready
ask for that rent.
Well, we are not bound to extend them. This
No, but it
notification
says
does
it
not
will
say.
be extended because 2026 letter and 2017 letter read together, they say it has to be. It doesn't say it can't be.
No, this is a provisional extension. Kindly see 4 and 5 also.
Therefore,
so it is the process which has to be followed for determining what is the rent. Subsequently, there is a procedure. Next page, Malad.
Procedure.
Procedure, kindly see. Next, third page, my lord. 4.
Page 4, internal page 4.
Internal third page, my lord. Third page, Roman 4, my lord.
Roman 4.
So these are the steps which has to be completed after, only when these
By
are completed,
DGT.
he has a right, my lord. His lease stands extended. Not only that, he has
This is when extension is done. This is how extension is to be done.
Correct.
But till such time that you do this extension, there is a deemed extension under BA. Because it is only B which governs the extensions.
It again say will be extended. So some other party has to, this is a notification of Ministry of Defense. Will be extended, my lord.
Because
Somebody
it is-
else will have to exercise that
No. It is
act of,
automatic.
it is no, my lord.
Has to be.
He has to, somebody has to exercise that work of extending the lease, pass an order of extending, because there are several steps therein. My lord, first of all, my lord, I am repeatedly trying to show this, my lord. Kindly see the procedure. Procedure says he has to the extension of lease will be done in schedule 4. So this extension has to be done by somebody. Third page, my lord, Roman 4. So until unless
Once this extension is done, that extension
that is
will
final,
continue.
then his lease stand extended for 1 year.
Roman 4.
And not only that, my lord, in 2022 notification, it has been said, kindly see, following are to be read after para 4. So that policy is being modified, my lord. The following are to be read after para 4 of third paragraph, my lord. Third item, first page 3.
No.
The following are to be read after para 4. The issue of breach laws, right to take action against dealing from payment of lease rent, acceptance of lease rent, or extension of right will be provisional, will not be Government of India or any of its functioning, including you, will reserve the right to take legal action. 5.3. Applicants may submit online application for extension or renewal of lease, as the case may be, on the basis of which a self-declaration as per Annexure A for extension or as per Annexure B for renewal will be digitally validated by them. Annexure B.
Mr. Chatterjee, it does not appear that it is mandatorily to be extended.
No, my lord. Yes, my lord. I
In
answered
any
my
case,
lord's question.
he has not followed this process. He has not followed this process.
I answered to the my lord's question. Now, my lord, he is interpreting this 2017 notification as there is no automatic extension. He is saying after this there is a process to be followed. My lord, admitted position is I have applied for extension. There is no doubt.
They may not
We are
extend it.
taking this position now. My lord, read this notification.
Yes.
Now, my lord, this notification is issued on 10th of March 2017.
Yes.
So, my lord, my lease has not expired by that time.
Not required. Whenever it expires,
No.
it's notification.
Why I say this? Yes.
No, but Mr. Chatterjee, let us cut the rhetoric. Let us come to the point, because we are losing time.
Right.
Your lease expired in 2025. At that point of time, say this notification is applicable. This notification was there in force.
Was there.
In terms of this notification, you have applied. Now, mere application will not amount to extension. There is something more to it.
Absolutely.
Which is to be done by the authorities. The
Yes.
authorities are not bound to extend. If they are bound to extend, then all this paraphernalia, which is
Just, my lord, the question is,
it
my lord,
goes to
whether
the
they are
dustbin.
bound to expend, and if they sit tight over their action, my lord, whether this notification saves
Yes,
me
you
or not.
show that. Yes.
Now, my lord, kindly takes one first page, that one extension of expired lease. My lord, first the caption. So, my lord, it is extension of the expired lease.
Right.
May I just place it the entire, this A part first. A full term of large number of cantonment codes leases given under the cantonment code, now such and such has expired, and for the remaining will be expiring soon. Similarly, a number of leases given under the cantonment land administration rules, such and such have expired after having completed full lease term. Ministry of Defense has been working on formulation of a new policy to deal with such leased sites whose full term has expired or is expiring soon, which is likely to take some more time. Therefore, to regularize, so they are regularizing by this. Therefore, to regularize the occupation of these sites from the date their full term has expired and to recover lease rent, the government has decided to take the following interim measures. So, Millard, these are the interim measures they have to take. First, government is regularizing, Millard, whose term has expired. Now the action is upon them. Now, Millard, BA is important. A lessee, all leases given under the Cantonment Code 1899 and 1912 and such, whose full term has either expired or is expiring before 31st December 2000, or will be extended till 31st December 2018, subject to the conditions given in succeeding paragraph. So there is an extension done because it is extended. And why this term is being used? Because this is in 2017. My kindly takes that note of, because this is something issued prior to even expiry in 2018. So, my lord, it is being used in past tense. I am regularizing. It is being extended. Now, this is conditions are to be looked into, subject to the conditions given. So, my lord, this BA 1, 2, 3, 4, 5 are the conditions. If I do not fall in these conditions, Millard, then Millard, my lease stands extended. Millard, there is no question of extension. Now, Millard, there comes on the how they will take the procedure. Now, Millard, it is them to ask for what they do on my expiry. Millard, during pendency of this suit, they issue, Millard, draw up a proceeding and issue an impugn notice which is under challenge in the suit. I have challenged that, Millard, notice. I say that notice itself is against, Millard, this policy decision which has come in. This is bad in law without taking into note of this 2017. And in the meantime, when this is pending, they, Millard, draw up a proceeding. Now, Millard, my learned senior friend argues that this is something not automatic. Millard, if this is not automatic, then, Millard, past tense would have never been used. It's always extension, not extended. Because notification of 2017 is saying about an expiry to happen in 2018. They are using a term extended. So therefore, Millard, a pre-notification is extending a post-expiry. And that the same is, Millard, now extended year to year. That is also an admitted position. In 2026, this notification is continuing, with the same stipulation that the policy is yet to come.
My lord, this sentence can be read in many ways, my lord. If we can exclude certain
meaning has to be given to past tense ED.
Yes, my lord. Past tense, there is also a future tense. Will be extended till. What is extended?
Therefore, it's mandatory.
Who will extend it without an application? 2022, 2022 application notification is not even being referred to, because 22 has come, then his lease has expired. It specifically says he has to make an application, online application with a self-declaration. He has not made that. He has just made a written application letter, and then he says transfer it to somebody else. And then he makes an application for transferring it to somebody else. And he transfers it. Under any circumstances, he cannot assume
on merit. If he wants to, Millard, on that also, Millard, I will argue whether I am permissible or not. Because my initial lease permits me to do so.
He can argue all these points before the before the
very well, Millard.
CEO.
If I can argue all this, then, Millard, kindly permit me to take my counterclaim there, declare for this impugn notice to be bad, declare, Millard, me as a lessee in view of this notification, whether that can be done under the PP Act. Because I am seeking a declaration of my right, interest in the property. Whether PP Act can do so.
He is a lessee.
I can have a defense.
He has a lessee. For the time being, he can at best be a lessee from year to year.
Very well, till such time protect my possession. I am saying for.
Such time, my lord, such time is, had it been a such time, my lord, PP Act would not have been
this Indian law reports or AR 1931 is exactly at that point. Millard, and the letter, Millard, which I have argued in change circumstances, shortened litigation, there cannot be an anarchical. They are also exercising quasi-judicial administration, this estate officer. There will be anarchy in judiciary. if this is allowed to happen.
What?
Huh? Holding of relief. Holding of relief.
What is the status today there in the hearing?
My lord, he has kept it, heard nothing. He said that an order from my lord seeking an adjournment, at least so that he can save his skin.
I'm
My lord,
putting it.
I just wanted to see so that he can answer it on the next statement. My lord, when he is contact, kothay? He is himself, my lord, kindly see page koto eta. No page number, lease ta koto number page. Eight. Lease
And when did you apply for extension?
Prior to this, my lord, before my expiry, that is admitted position.
Where? Show me that.
Yes, the acta আছে.
It is not admitted. He says
Possibly,
it's not applied.
possibly 2023
Yes, yes.
or 2023 possibly.
2023,
Almost
I have applied, my lord, one document which was before the trial court. I just referred to that.
Only when it was supposed to expire.
Absolutely, before the expiry, I will apply. 98 kindly takes page 95. Sorry, my lord. In that document, there is a reference which was there, and he admits, my lord, in 2023 also we have applied. Paragraph page 101.
101 এর পরেই হবে, 91 এর পরেই হবে।
101 what have you?
101, my lord, the second paragraph, I therefore request you on behalf of my to proceed and comply with the notification dated 2017 to regularize the occupation of the leasehold.
But this is an advocate's letter.
Yes.
This is an application by the lessee.
Yes.
How can this be an application for extension? An advocate's letter.
My lord,
এই তো।
This is something which you cannot even say that it is an application. You are issuing a section 80 notice.
my lord, it is being applied, my lord, just
এটা দেখো, এটা 2023
10th January. My lord, give me
undertaking এর আগে।
undertaking এর আগে। Just page 63.
Mr. Mukherjee, come tomorrow morning. Come prepared, show me. Taking lot of time. Others are also standing.
Yes. Well, in his reply, my lord, I will refer to the original set deed, my lord.
List.
My lord, my lord, today he has, because we have not participated.
Softe থাক কারণ কালকে আবার তো লিখতে হবে ওটা। আপনি সফটে দিয়ে দেবেন না, আমার কাছে সফটে থাকবে না, লাইনে পাঠিয়ে দেবেন। Yes, what are you saying?
My lord, they have, my lord, just, my lord, held. But they are saying that if no order is there, my lord, we wish, because we have not participated, we are filing only adjournment petition.
Why are you not participating? You
My lord,
participate.
because my lord observed that pray
But,
for an adjournment. By an application, we are praying for an adjournment.
Written reply. They can.
Reply. Why are you not filing your
My lord,
reply?
two things. My lord, when they serve a notice, they have filed a plaint. By an application, we have asked, please provide us a copy of the plaint so that we can give a detailed reply.
I have taken instruction on that.
They have not.
They are referring to the same plaint, my lord.
Which plaint?
Which,
How do
they
I
have
know?
filed.
My lord, how do I know? In a section 4 notice, they say they have filed a plaint. My lord, I have said I sought for that plaint. How will I reply? My lord, if they don't supply.
If you are not, if they are not, if they are violating your.
That will be a very good ground for setting it aside.
Carry up in writ, my lord. Then my lord kindly keeps it open, my lord. As of date, my lord, we have not filed our reply also.
Overreaching someone else's jurisdiction.
No, my lord, they are saying if today there is no order, they will say we have failed to reply.
I cannot say a state officer should not.
No,
proceed.
adjournment. Just, my lord, adjournment for detail.
What basis? It's not there before me. That is why I have not been passing orders on that. I cannot pass orders sitting here. This is
My lord, there is a Supreme Court, my lord, brought today. My lord, saying that change circumstances can, my lord, mold reliefs.
They have got sufficient.
To be something in. I cannot in the air say that no. From today you will come with without spectacles. I cannot pass.
In fact, this first notice was.
And then today, if they pass an order,
I'll hear it tomorrow.
But if they pass an order, my lord, where
challenge it. Because you should have participated. Why did you not participate?
My lord, as fell from my lord on that day, please seek for an adjournment. We prayed for an adjournment.
If you see that they are not, I did not mean to say that you seek for an adjournment and don't participate at all. Go on.
No, we were participating with filing applications. Look, my lord is in session of the issue.
Taken your defense also.
Well, in their first, second and third hearing, they did not even inform the PP that the
my lord is keeping it tomorrow. My lord is keeping it tomorrow, my lord.
Yes.
So, my lord,
I will not observe anything about the estate officer. That proceeding is not there, Mr. Chatterjee. It will be.
Then, my lord, I have to amend, my lord, injunction. I have to amend plaint and bring everything because this has happened, my lord, now.
You should. I cannot, by way of judicial order, amend your plaint. And
if I can show, my lord, subsequent events.
Mr. Chatterjee, everything cannot be done because it is 227. Don't argue things which
No,
cannot be done.
I'm not. We're in civil court.
Then
Under, my lord, Code of Civil Procedure.
Provisions of Order 6, Rule 17 should be wiped out.
No,
Then
not at
if
all.
subsequent event, because you have filed a civil revisional application, during pendency of a suit, something happens, you will get an amendment in an order by.
No, not at all. This is not my submission.
So
What I am saying, court can take note of subsequent events.
taking note of subsequent events only if those subsequent events are brought by on record by way of pleadings. You do not bring it. This is a continuation of the civil proceedings which are already there in the form of a suit. I am not exercising writ jurisdiction in that sense. It's a revisional jurisdiction against an interlocutory order. I cannot expand it in such a fashion that I will go on amending plain to your pleadings before the appellate court. That is not done.
Absolutely.
Then
what is there, Lord, on record.
Therefore, don't make me.
Since both the parties are.
That is why I have been cautious enough saying that no, you please go. I cannot pass an order saying that no, stay it. Advise your client accordingly. Please participate in proceedings in the manner you should participate. Adjournment means only adjournment. You will not participate at all. Then you are.
Today, kindly visualize me that I participate. They would say they have participated. They have foregone their right. Two ways I am cut.
You know how to participate without foregoing your right. There are ample avenues. I have also been on that side. You know how to advise. Mr. Chatterjee, don't. I have lost that advisory jurisdiction now.
Since both of us will not agreed on the previous occasion, that's why I was just visiting. He can will not apprise. Since my lord is into this and will not point
these things.
This something.
In
will
that
not,
case, I could not have. I
They
would
are
not
also-
have said anything.
They are also guided by time because under PP Act there is statutory time limit.
That's exactly not why they are hurrying something from this.
Tomorrow, heard learned advocates appearing for the respective parties. List this matter tomorrow. Tomorrow I'll hear it out.
May I have a copy of this order to be communicated, my lord, in the my lord has heard today. At least this much I can show them.
Yes, show it. It will be up on the server.
Yes. But the affidavit of service may be kept. আমি কি বলছি ওকে দিয়েছেন ও তো সাইডে কোনটা তোমার আর সাইড করে নিয়ে যায়নি
Well, may I take back my book, well, or PP Act.
PP Act I have given back. দিলাম যে একটা PP Act. এখানে নেই তো এইটো এখানে.
Great. Only one thing, Lord, if this can be taken up fairly at the top, because I will be in a soup, Lord. If something happens, then Lord.
At the top.
Lord, I am for the for eviction, Lord, I am the defendant. By the order impugned, Lord, my evidence of DW1 was closed and matter has been fixed tomorrow for for argument. Lord, I plead for time before the trial court on the ground. Lord, another civil revisional application is pending before this honorable court. That is, Lord, appearing in the monthly list, item number 329. And on this ground, Lord, I prayed for an adjournment. That adjournment was rejected and the order impugned was passed.
What is the order on the basis of which you sought for adjournment? What is CO 416 of 2025?
But that is pending before your lordships, item number 329.
What is
Lord,
that?
151 application was filed for repairing of the suit house.
So for that, why should the suit not proceed? For 151 application, why should the suit not proceed?
Lord, I pray for only one chance before the trial court, Lord.
So why did you not participate there? That was no ground for adjournment in any case. That was no ground for adjournment. Your repair application could have been allowed. Even
Kindly
by
fix a date on that particular day. I will.
No, without the other side being there, how can I fix a date?
Lord, I will go there and work.
You cannot pass an ex parte order.
Yes. Then, Lord, kindly allow me to effect service upon the opposite party.
This revisional application is directed against an order
My application, my lord. My affidavit of service, my lord. They receive on 9th, my lord. Losses kindly see losses last order on 25th March 2026.
Yes. Yes, sir. What is your grievance with the order?
Order, my lord, that is, my lord, the order passed by the learned trial judge allowing the petitioner, my lord, that's last
He has
order.
granted them liberty to proceed under Order 21, Rule 41. What
That
is
cannot
wrong
be
with it?
granted, my lord, without any application. That is, my lord.
For an order to be passed under Order 21, Rule 41, they will file an application.
Yes, ma'am, that not filed. And that lawsuits can give him that liberty. But without that, they cannot
No,
go.
he has not. He has done only that. Granted
No, no.
liberty means liberty with liberty to file.
That is not mentioned in the order.
That is the
And
meaning.
that
I will
one,
clarify
Lord
that.
Justice kindly say two things, my lord.
I will clarify that. That
My
is
lord.
the meaning.
And Lord Justice, another thing, my lord. Lord Justice kindly come to order on the last page. Yeah.
Yes.
Last but one page, para 22 of the judgment. It is made clear that in view of the order 21 Rule 48.3 CPC, if it is found that the salary was disbursed in contemplation of the attachment order after due service, the employer disbursing authority may be held liable for make good such sum in accordance with law. They will recover from the salary of the employees. And then, my lord, the degree holder is granted liberty to proceed with the execution of the lawful and also waive the limitation, without limitation, that is.
That is not the meaning. Waive limit. It is not the meaning that it is not the sense conveyed by the order that for prescribed period of limitation has been waived. This has been used in the sense of number of modes. It is not that only this mode will be applicable.
They have to file application under limited.
That I will clarify.
Malad, the losses can come to another thing, Malad, order 41, order 21, rule 41.
Yes.
And losses can come.
Yes.
Where a decree holder for payment of money, the decree holder may apply to the court for an order. This is, my lord, order, and the judgment debtor. The judgment debtor is in corporation of the office of thereof and any other person by orally examined to be whether any or what debts are owing to be judgment debtor and whether the judgment debtor has any and what other property or means of the satisfied degree. The court may make an order for the attendance of examination of the deeply judgment debtor or office of the officer or the persons for the production of any books or documents. Then, my lord, two, my lord, whether a decree holder for payment of the money has.
Understand. These are all when he makes an application.
Yes, that
So
is also an
I will
application.
say that it means that it will only be taking effect when he makes an application. That I'll clarify.
Yes, that is. If he made application, then only.
Affidavit of service filed in court today is taken on record. I'll have to deal with your judgments. So it will take time, and others are waiting because all the matters have been contested since morning. So let me finish some.
Only
I'll see
kindly
tomorrow.
permit me, because this was not served. We have also obtained a certified copy. If any query falls from my lord, we have also
of course.
obtained, my lord.
I'll just not start passing order. I'll hear you.
না, না, আমি একটা তুলে নিচ্ছি certified copy.
Because there are 2-3 judgments which you cited, so I'll have to deal with them.
কালকে হবে আজকে এক্সটেনশন হবে গেট খুলে গেল
Only not today, nothing. Yes, চলো next call করো। কিছু টাচ করে যাই, নালে অনেক বড় বড় ম্যাটার হলে অসুবিধা নেই।
My lord, I appear on behalf of a petitioner, my lord. I am seeking
lord.
for short accommodation in this matter, my lord.
My lord, I'm appearing on behalf of respondent Bank of India. I'm just kindly grant a liberty of not today.
My lord, will it be possible to fix this matter any date in the next week, my lord? I'm under some personal difficulty in this week, my lord. That's why I'm any day next week. Huh?
Not this week.
Any day.
Yes, I'm making it not this week. It will not be taken up this week.
Yes, my lord. Any day. Grateful, lordship.
আচ্ছা লিখে নিন, তাহলে একটা অর্ডার লিখে নিন। As prayed for $16 লিখে নিন। None appears for the petitioner. No accommodation is sought for. Next.
My lord, I am appearing on behalf of the respondent.
I'm for the petition. The evidence service. I'm for copy. Yes. Lordship, this is against the order 47, the petition is.
We have
Originally, the land my wife belongs as a gifted deed. They have gifted by one Samar Doctor, Lordship. That I am after disease of my wife, my son and I am residing at there a small part of land. There are 2 decimal of land, and a small mud built house. The same is a mud built house, and I am my deceased wife was belong as a registered deed by dated 29 March 2005. 2005, Lordship. They have gifted by one. Originally, this land is belong to Akhoy Bhushan Doctor, and their predecessor and subsequently their successor, Sudip Doctor, they have, by virtue of registered deed of gift on 29th March 2005, they have gifted to one my wife, Lordship, that is what is the name? Mohsina Begum. And I am the husband of the deceased Mohsina Begum. Matter is that my son also filed a partition suit before the learned civil judge senior division
Rampura. The same is pending, and then the learned court also given please to pass the order of a injunction until the disposal of their suit. There is parallel to suit is going on. Now the title's execution is pending before the
May I submit before
Lordship? Complete. Lordship, can you come for a ground portion of the miscase 12 of 202? Opposite with neither owner of the land. I am the.
No, that has been decided in the suit. What is
Lordship.
your ground in section 47? You say that.
Lordship. And also subsequently there is a second appeal is pending before this Honorable High Court.
That is neither here nor there. You have filed your section 47 application, that has been dismissed. What is wrong with the order? You show me that.
Order of this. Lordship.
বলছি স্লিপটা একবার দেবেন স্লিপটা
একদিন কতটা কোথায়
আরেকবার দিয়ে দাও স্যার
না অর্ডারটা চাইছে টাইটেল this one. Lordship, there is no pagination because it's the original one. I do not find any justification in entering and allowing this instant case as there appears to be a no legitimate grounds on reject the execution suit filed by the degree holder. Hence, a miscase is failed. In order to cause the instant case is disposed of on contest, miscase is stand disposed of. Parties are directed to appear before next date. Now, next date is on 18th of this month, 8th or 18th of this month. But Lordship, my contention is that the degree holder is not a owner of the land, and this is a large
that cannot be gone into by the executing court. He cannot.
Lordship, and this is that is a parallel on another partition suit filed by the deceased son, and make party all the.
Cannot be gone into by the executing court. Yes. Only questions regarding this execution and discharge, satisfaction. These three.
Lordship, this is
go into questions which you could have asked before the suit court in the suit. Execution, discharge, and satisfaction. Only 3 points.
I am the owner of the land, and I am purchased by virtue of the
ownership has been decided against you by the suit court.
But
appeal
there is no issue of the appeal dismissed, and
second appeal has been already dismissed for.
No.
And you
Second
said pending.
That is pending, Lordship. That is dismissed for default, and subsequently I filed the restoration application. I filed.
Even if it is pending till such time
Second
that there is stay, execution has to proceed. Now, in any case, I am not concerned with that because you have challenged the section 47 order. You have to show that the section 47 order is bad. He has rightly held that he cannot go behind the decree. What is wrong with the order?
There is a concurrent findings, man.
And what about his contention that the property is vague?
He is the owner of the property.
He says that the property is vague. It has not been properly described.
This is large.
It has been properly described, and the execution court has rightly passed the order. But
how do you say it is properly described? Where is the plaint? Show me.
Right now we are not carrying the plaint. I have to take.
Not today. Bring the plaint tomorrow.
Well, not tomorrow. But it is not this week, my lord. Because staying in Rampurhat, my
lord. Your execution is being stalled. Bring it tomorrow.
1 week accommodation, my lord. Otherwise, I will suffer irreparable loss.
As prayed for by the learned advocate appearing for the opposite party, list this matter after a week. ये extension गुलो call करे दिल दिते सबाई बोशे आछे भीड़ होये गेछे
Yes, 1 week.
I am for the petition in item number 241. My lord, I am seeking extension of interim order of pay passed in my lord order on 4th February 2026, my lord. Third paragraph.
Other side?
Service has been completed, my lord. It is fifth time service in compliance of the honorable court's order, my lord.
What is the
Service
order
has been
impugned?
effected, my lord. Preemption case.
What is the order impugned?
My lord, my order 6 rule 17 filed in connection with the preemption proceedings filed under sections 8 and 9 of West Bengal Land Reforms Act has been refused. Against that, before your lordship, this revision application has been filed.
He is not appearing after 5 services.
My lord, this is fifth time service, my lord. Service has been effected upon the opposite party.
लिखें नहीं. None appears for the opposite party despite service. The interim order expired on 22nd April.
4 months it was granted.
22nd April.
22nd April.
What was the interim order? Nature of stay.
Stay.
When is the next date?
Next date, my lord, today was the next date, the date fixed before the landed court below.
Order 26, Rule 9.
Yes, my lord.
This is the first service.
No, my lord. Opposite party appeared. The interim order, when the interim order was granted, my lord, in presence of the opposite party, the interim order was granted, the first interim order.
लिखे नहीं. Why don't you serve the advocate who appeared?
The advocate is appearing. I have served advocate also.
Affidavit of service filed in court today is taken on record. in once.
one. This is analogous.
ঠিক আছে, ওটা দিতে হবে।
But I'm for the petition opposing, my lord. But interim order granted by this honorable court on 15th of May 2026. My application for acceptance of lordship, the counterclaim was rejected by the ordering. The interim order was passed on 15th of May 2025. It was extended time to time. And lastly, it was extended on 22nd of December 2025.
The claim was rejected. Why?
On the ground of limitation.
May I, yes, Your Lordship, the suit for partition was filed 2018. Initially, written statement was filed in the month of June 2019. Now, after adducing of evidence, came up with an application.
The partition suit was filed on the ground claiming the title on the base of an unregistered deed. The case in the print was that the deed
It
could
can
not
be finished off shortly, or it will take.
In my humble submission, this order cannot, the provisional application ought to be dismissed. Your Lordship kindly sees the.
May I, is my case, I'll satisfy your lordship. I cannot satisfy your lordship. Now, your lordship.
Extending it for a limited period.
And my lord, kindly fix it matter. Will not. It's a very short matter. It will take only your lordship's 5 minutes time.
The interim order. Contested করে দিন।
মাত্র।
245, my lord, I am for the petitioner. Initially, interim order was granted. The interim order granted on 7th of May 2025. The interim order was granted on 7th of May 2025 for till September 2025. Therefore, my lord, it has been extended till February 2026. And my lord, after that, my lord, an application for extension has been filed because in the meantime, the interim order expired. Since my learned junior missed that the interim order expired, I have filed this application with the explanation in paragraph 5 and 6. And my lord, your lordship can fix the date for hearing and kindly extend the interim order or reimpose the interim order, my lord.
I am opposing this pair, my lord. My lord, first of all, the interim order already expired, my lord, long earlier. And
what is the matter? What is
the matter is very short.
The interim order,
my client, my lord.
This is my application, my lord. May I? But plaintiff has filed a suit for declaration of title and injunction. In such a suit, my lord, he has filed an application for appointment of a handwriting expert. The document was sent to the handwriting expert for examination under Section 43 of the Indian Evidence Act. My lord, we took up plea, my lord, since the document has not been tendered in evidence, my lord. Document is premature, it cannot be taken into evidence. I have shown a judgment of this honorable court. The learned judge has accepted the prayer and stayed the proceeding. And in presence of the other side, my lord, the stay was granted. Therefore, my lord, fix the date. I need the Milton, my lord, my application, my lord.
My case is that I am the owner. I am the owner of the property, and I have paid for declaration and injunction. Defendant, in the written statement filed, stated that I have executed 3 deeds in his favor. My lord, I am 80 years old lady. My lord, I have, that's why here he is saying that I have executed the deed. So I have, there is no denial of the fact that there is a deed in his favor. So there is no question of disputing the same. Let it be examined by handwriting expert, because I am 80 years old. If I my lord die, my lord, totally, my lord, the defense, my case will go, because I am the person who can say
that whether it is my signature or not, and my lord, signature can be verified, my lord, or whether it has been done. This is not a case that defendant is disputing that there has been a dispute, but defendant in the written statement has embanked upon that deed, that allegedly I have made deed. So where is the scope? This is not a case of that type, that it is to be exhibited and it is proved, then it is to be done. It is not, it is his case.
Well, this is the High Court judgment.
Yes,
he considers.
that judgment.
That judgment kindly considers that the suit is not mental. Yes. Well, this type of suit
depends on the context of the case.
No
declaration. Lord, any date may be fixed. Any
yes,
date
well,
may
that,
be fixed.
But Mr. Chakraborty, you have denied the execution of the deeds.
Yes.
Yes, I am denied, and he is saying that I have made deed in his favor. So let it be examined. My handwriting be examined.
Done, my lord, until
my handwriting be examined.
My lord, the document cannot be. This is
Whether
premature, my lord. That
it has
is the
been
Supreme
done
Court
by me.
judgment.
Well, I am 88 years old.
Kindly extend the interim order and fix the date any day.
Any date may be fixed. Tomorrow, day after tomorrow, or any day.
As a contested
Any
application, kindly fine.
Any day it may be fixed within 1 to 5 days, whatever the court may convenient. এই জাজমেন্ট আমাকে রেফারেন্সটা দিন তো, কনটেক্সটটা আমি দেখে নেব। জাজমেন্ট রেফারেন্স, মে আই কাম টু নো দ্য রেফারেন্স অফ দ্য জাজমেন্ট?
আমি দিয়ে দিচ্ছি।
দিলে না তো, দুবার তিনবার বললাম, দিলে না।
এটা একটু ওনাকে দিন।
আপনি
লিখুন, Can 1 of 2026 has been filed seeking reimposition and extension of the interim order granted on May 7, 2025, which was subsequently extended on September 24, 2025. Full stop. Having heard the learned advocates appearing for the respective parties and having considered the material on record, the interim order initially granted on May 7, 2025 is reimposed.
88 years old, my lord.
I'm fixing it. Is reimposed. Full stop. The same shall continue till the end of June 2026 or until further orders, whichever is earlier. Full stop. List this matter as motion.
Earlier direction to the contested application.
I'm bringing it up as motion. List this matter as motion a week hence. 1 week hence.
Okay.
Next.
Madam 246, I am for the petition. This is an order under challenge of the section 9 of the
I appear for the
petition.
opposite parties in this matter.
I am also late, my lord, I am led by also Mr. Chatterjee. However, this is the matter, my lord. The application has been filed under section 9 of the Public Premises Eviction Act. And on the basis of the order, my lord, the learned 10th bench considered the eviction notice. Eviction notice, that is, first order is, my lord, 9th June. Kindly see the 9th June order. That is sufficient for you. The 9th June.
May I submit? The first, the matter came up on 9th of June 2025.
I am submitting. Please wait.
Yes.
So, on the very first day, the point of challenge before your lordship was that the statutory notices under the Public Premises Act, they were not served upon the opposite party therein. That means the tenant.
No, that is not.
So that was the point of challenge. That is also recorded in the order of 9th of June 2025. A stay was obtained, interim order was obtained on that basis. I provided with a copy of the 3 statutory notices under forms A, D, and F on 20th of June. That was also recorded in the order of 20th of June. Thereafter, the matter was never taken up for hearing and the interim order got extended from time to time. So the statutory notices were duly served. That is also there.
I'm extending it for a limited period because today I cannot hear it. It will be there.
Lordship will kindly fix this matter because LIC is not being able to utilize the valuable property
Just doing it.
in spite of having evicted the tenant from the premises.
Having heard the learned advocates appearing for the respective parties, the interim order granted earlier is extended till the
Current rate not deposited within 15th of succeeding month. Matter was pending, 7-day advertised. Ultimately, judgment came. Lordships would recall, on the earlier occasion, it kept up, it has been fixed after a long period of time because Lordship was be going for the circuit.
I'll
Fix it any day and new motion. This is one submission.
Lordship, my extension application is already pending.
yes, I'll hear it out.
Yes, I don't have a problem.
11th, if possible.
New motion. Monday, new motion.
Grateful.
My lord, may I have your lordship's kindly to mention
261 টা কল করে দিন ওনার কালকে কি হয়ে যাবে বলছেন
my lord 258 259 my lord my interim order will expire tomorrow.
250 কল করে দিন 258 259 আর 260 till tomorrow. Then not a problem. Those whose interim orders are expiring today, I'll have to.
Tomorrow. 259.
When is it? When? Yes. Matters whose interim orders are expiring today, I am calling.
No, my lord, yes. তোমারটা কালকে এক্সপায়ার হচ্ছে expiring on 6. My lord, it will remain in the list, my lord, I believe.
লিখে নিন 61
Mr. Mukherjee is there, Malad. Kind of fix it. Malad 260.
উপরে করে দিন
248 and 249.
Suppose a new motion রেখে দিন dispose of হয়ে যাবে
New motion.
Next two matters are there.
260 other side.
There is a new motion tomorrow.
248 and 249. Malad, the interim order, Malad, same, Malad, Mr. Mukherjee. Kindly extend it and fix the matter.
Yes, 48 to 49.
Yes. 48, 49. After 2 weeks, Malad.
260 the other side is there.
না এটা হচ্ছে
Tomorrow. Tomorrow I'll be taking
248,
130.
249.
There is no caveat. Then your caveator should be there. Bring your caveator tomorrow in the morning, mention it.
Well,
I'll take
248 and
it up.
249, Mr.
240, 249 এখন কোনো motion hearing হবে না এই সময় কোথায় শুনবো
Well, these are the two matters, well, wait for the petitioner. The matter relates to a preemption case. Well, the interim order is there, well, you kindly fix the matter.
Interim order is over. Now they have taken out an application
I'll
for
be in
imposition.
I'll
The Lordship will kindly make it for a limited period.
I'll-
Fix for not hearing.
Hearing.
But they have lost both the court
Yes, yes.
and the question is very large.
Yes, yes, yes.
and
After the
1
vacation,
of
হবে?
2026
Yeah, those service.
Well, after the
করে 249 এ same order করে।
Great.
Why it is expiring today? 250 টাও call করে দিন।
get a last. Well, both the matters will appear side by
Appear
side.
accordingly.
Yes, yes. Grateful.
Tomorrow, what time will you be able to come?
250, my lord, this matter was initially admitted by my lord.
Opposite party.
Tomorrow is a date fixed, my lord. Earlier occasion, due to illness, I could not come, my lord. It was made out of this. It came under heading extension of interim order itself, my lord. If my lord kindly extends for a short time and fixes a here for hearing, my lord.
I do not oppose, my lord.
লিখে নিস।
Any day kindly fix it. It is 5 minutes issue, my lord.
Third learned advocates appearing for the
Item number 82, my lord. The listing date I had given as 13th May, my lord, but it is suddenly appearing today.
very well, not a problem. It will be taken up on 13th.
With your lordship's permission, may
13th এর date দেয়া আছে ওটা you please
Item number 82, I will indicate. I will indicate. Grateful.
with your lordship's permission, may I mention item number 253, your lordship. I apologize for appearing virtually, lordship. I'm logged in from Delhi. Lordship, this is item 253 and interim order was passed against continuation of the arbitral proceedings. Since July 2025, the arbitral proceedings are lying state because of this petition. The challenge is that the learned arbitrator has declined the request of the petitioner to lead evidence of the second witness. This is purely a procedural order. Initially also a 34 was filed, a section 34 was filed against
I'm not
rejection of an
hearing,
amendment.
Mr. Counsel, I'm not hearing it now.
Lordship
hear
may
it
just
when
give
it
me
is
a
called
fixed
on.
time. I have to travel from Delhi and argue the case. So Lordship may just give me a fixed date and time whenever it is convenient to the Honorable Court.
Let the interim order be extended. Let the matter be kept any day, or we can argue.
No, Lordship may just give me a fixed time and date. I'll argue the matter.
You tell me a date, I'll fix accordingly.
Yes, Your Lordship. Lordship may consider keeping it on 11th of May if that's convenient to the Honorable Court.
11th May আছে আমাদের কিছু। May, we have a lot of fixed matters.
Lordship may consider keeping it on 13th then?
No, 13th also I remember having fixed matters. Today itself we have fixed.
Lordship may keep it on 18th if that is convenient.
18th we can have it.
18th.
18th আমার মনে নেই কিছু।
And let the interim order be extended till some time, or we can argue on 18th.
Call করে দিন ওটা।
Lordship may just consider keeping it a fixed time because I have to travel from.
Yes.
Yes.
Item number হচ্ছে
253.
253.
I have an application also listed for vacation of interim orders. IA number CAN 1 of 2026.
I'll be hearing of the revisional application itself on that date. So
that's all right, Your Lordship. Lord, if I may only request to give a fixed time, Lordship, because I have to travel to Calcutta to argue this.
Very well. We'll fix it at 2 p.m.
2 p.m. on 18th May. Great.
লিখে নিন দিদি, লিখে নিন। CO 2654 2025. 4. OCL Iron and Jindal Coke.
Yes, Your Lordship.
Yes. Having heard the learned advocates appearing for the respective parties, the subsisting interim order is extended till the end of June 2026 or until further orders, whichever is earlier. Full stop. As jointly suggested by the parties, list this matter for hearing at 2 p.m. on May 18, 2026. 18th May, 2 p.m.
Grateful, Your Lordship.
Your Lordship, item 100, new motion, Your Lordship, it's a small matter for expeditious disposal, Your Lordship.
Not now.
Lordship, kindly give some precedence so I can place it tomorrow, Lord.
Lordship, item
Tomorrow, Lord.
250, my lord, is kept on the 10th of June. I have a personal difficulty, could be 11th. Just one.
Item?
250, my lord has been pleased to keep on the 10th of June.
250, did I pass an order?
Yes.
Somebody was there.
Yes, they were there. I shall put my learned friend on the other.
11 June করে দিন, 11 June.
So very obliged.
Give this number, it will appear as new motion. 130 টা new motion এ করে দিন। ওই 130 দিচ্ছেন, ওটা new motion এ করে দিন।
Lordship 257, Lordship 257, Lordship.
Extension of interim order, Lord, 257. Any day, Lord, may be fixed for hearing and interim order may be extended. It has been extended last by
Section 5 of the 7-1.
In person, open. In person.
This one,
255.
257. Extension. Lord, kindly see the order passed by the Justice Bhattacharya, Hinanmoy Bhattacharya, on 9th September 2025, that has been extended. Yes.
वो तो in person की नहीं advocacy दिया, in person को भी नहीं bro.
Affirmed by the Honorable
In person.
No, that order is not there.
No, this is fresh. No.
Kindly see the first order.
This 7-3.
It has been recorded everything. Yes. You are in person. Where are you guys?
Yes.
You are in person. How can?
This fellow is who is
No, I'm
this
not.
fellow?
My blood.
Who is this fellow? No, he is not repaid.
This is the attitude. Within
Interim order was passed. But your lordship knows it.
And that matter has been fixed by Honorable Justice Champa Sarkar in earlier occasion. Earlier occasion.
This matter is not.
Yes, but the interim order is there.
Yes.
No, that has been expired, Miller, kindly see. This
It was in the list, Lord.
In the list.
It was in
Has
the
already
list.
been
All along
expired.
it was in the list.
Yeah,
We
another
mentioned the
thing,
matter for interim order. It was all along in the list.
Lordship,
Has already been expired, Miller.
I can mention the
During.
in the pending.
Has already been expired. A very short matter, Miller, I pay to.
Yes, any day may be fixed, Lord, for hearing of the matter. We are ready.
This matter will
When is the next date before the trial court?
Trial court कब है?
Next date, 15th July, in the month of June.
Very well. এটা রেখে দিন তো
At the end of June.
11 তারিখ রেখে দিন 11th May as notion.
11 May.
Till then,
I'll hear it out.
till then, still.
I will hear out.
Till then, still.
At least till the 11th May,
I
let
will
there
still hear out on 11th. It will appear as no motion. পরশুদিন
Sure.